Good morning, my sister. Sorry about that. I was having some difficulties connecting here.
Okay. Can you switch on your video for us, Judge Malindi?
I can see myself here. I don't know if everyone else can see me.
No, I can't see you. Sorry. Can you assist Judge Malindi?
Otherwise, I may have to leave and reconnect. My registrar advises me.
I think you can do that. We'll wait for you.
Thank you.
No, you're there.
All right, there you go. We can see you now. Deborah, see if you can assist Judge Malindi.
Okay, Judge, can I be excused for a little bit, please?
Thank you.
I think I'm back, my sister.
Thank you, my lady.
Can you see me?
I can see you, Judge.
Thank you, Ms. Taba.
Thank you. May proceed then.
Today is the 13th of April, 2023, in the High Court of South Africa, Gauteng Division, Pretoria. This is case number 006386 of 2022. Before the Honorable Justice Collis J, the Honorable Justice Malindi J, and the Honorable Justice Mota AJ. The matter is heard via Microsoft Teams. Thank you, my lady.
May it please the court, I appear together with Mr. Ramukhali for the applicants.
Yeah, I just wanted to put the applicants' names on record. Apologies, counsel.
In the matter between Vendiren Makarite, the first applicant, Zimbabwe Immigration Federation, the second applicant, and the Minister of Home Affairs, the first respondent, Director General of the Department of Home Affairs, second respondent, Minister of Police, the third respondent, National Commission of the South African Police Service, the fourth respondent, the President of the Republic of South Africa, the fifth respondent, and the Border Management Authority, the sixth respondent, and South African National Defence Force, the seventh respondent. May it please the court.
Thank you.
Thank you, my lady. I appear with Mr. Ramukhali for the applicants.
Thank you, Mr. Nkaitobi. For the respondent.
If it pleases the court, Justice Collis, I, together with Mr. Rosenberg, Ms. Adakari, and Mr. Ibrahim, appear for the first and second respondents. As indicated previously, Mr. Rosenberg will be conducting this part of the or this matter.
All right. Thank you, Mr. Thank you. All right. Mr. Nkaitobi.
Thank you, my lady.
Perhaps could you just start by indicating to the court how much time do you want to be allocated for your argument when you commence?
Until 12:30, my lady.
All right.
And hopefully not more than 30 minutes for reply.
Okay. And the respondents, Mr. Rosenberg?
My lady, if the applicants go on till 12:30, we anticipate then that we would probably go up to about 4 o'clock, leaving the half an hour for reply.
It's also a lunch hour.
Yes, now I've factored that in.
Okay. So it's how many hours?
I would anticipate then that I would be approximately 2.5 hours.
Also 2.5. Okay. Thank you. Yeah, thank you, Mr. Rosenberg. Mr. Nkaitobi?
Milady, may I just put one aspect on record? It may be necessary for us, for the respondents, to deal with an issue up front, and that's in relation to what we now understand is the exact form of final relief that is being sought in this matter. And in the context of what we previously understood was an indication flowing from the short supplementary note filed late on Thursday last week, that the applicants were not going to persist with the application for interim relief. Having seen now what the proposed course of the applicant is, and the nature of the final relief that it seeks on these papers, there are certain preliminary submissions which we think should conveniently be made before counsel for the applicant moves on with the argument in support of the final relief that is sought as presaged in this draft order.
Okay. I think we must first find out from the applicants how they wish to proceed.
Yes.
Get that on record first before you can raise this point up front.
My lady,
on record, yeah.
we confirm that we will be asking for final relief in the form of the draft order that was uploaded yesterday midday on case lines at 010/1.
And will you be seeking final relief without any amendment to your paper as it stands?
Yes, it's final relief on the papers as they stand.
Okay. And is it the argument of the applicants that the evidence borne out by the paper supports the final relief?
Yes, a clear right is established.
And when this matter was enrolled, it was enrolled for the purposes of Part A.
Yes.
Of the notice of motion. Are you still just persisting with Part A?
No, with Part B. The final relief is in Part B.
That was not enrolled.
Yes.
Okay. All right. Thank you, Mr. Nkaitobi. Mr. Rosenberg?
Thank you, Judge Collis. As has been confirmed by counsel for the applicants, the matter has now, having been enrolled for Part A adjudication and papers having been filed in Part A, with no Part B papers having been filed, counsel has now migrated the matter, or the applicants have migrated the matter to Part B on the basis that the Part A papers demonstrate a sufficient basis for setting aside the decision in question, and that on that basis, the Part B relief is appropriately to be sought at this stage and on these papers. We submit with respect that cannot be. This was an application brought in two parts. For the purposes of the Part A relief, the requirements of interim interdictory relief were at the forefront of the papers as they were prepared and formulated. For the purposes of the Part A relief, there was never any question that the court was going to reach any final definitive view on the Part A relief. In fact, the court will be aware that in decisions such as Alta, Justice Moseneke indicated that in general, in many cases, no view will be expressed on the prospects of the Part B relief. In other cases, as it is indicated in the applicant's own heads, a judicial peek, to use the phraseology of the applicants, will be taken at the prospects of success. In other cases, in order to balance up the competing requirements for interim interdictory relief, a closer look may be taken at the prospects of success. But the clear and crucial factor is that at no stage in the Part A proceedings is a final view ever taken on the Part B review relief. And I'm making these submissions particularly in the context of an interim application pending a review. That gives rise to particular considerations, amongst which is the nature of the prima facie right that has to be demonstrated. It has been said, of course, that the prima facie right that has to be demonstrated is not just the right to review. Again, that was the dictum of Justice Moseneke in Alta. In certain circumstances, it may be necessary to have regard to prospects of success in the review if those prospects of success or a successful outcome is relevant to the right which is sought to be protected. So it all depends. In the present matter, the court will have seen that this application was instituted on a Part A, Part B basis, and the Part A papers, the answering affidavit on behalf of the Minister and the Director General, in paragraph 10 at 003-8 of the case line's reference, it's in terms indicated this affidavit deals only with the interim relief sought in Part B. In Part A, as Part B of the review application is to be launched within 15 days of the grant of an order in terms of Part A. And if one were to turn to paragraph 42 of the reply, which is at 004-12 in case lines, one sees there the corresponding recognition by the applicants that, in fact, the papers in due course are going to be supplemented, and depending on the nature of the record, that would determine the extent to which the papers would be supplemented. They say in paragraph 42, the respondents further review that the relief sought in the part B, sought in part B of this application will only be precluded by the principle of res judicata or issue estoppel. The applicants are reciting a point made by the respondents that this was an inappropriate procedure, that is to say interim interdictory relief was an inappropriate procedure to adopt in an application which is effectively being heard with applications where the main review challenge will be determined finally by the very same court that is hearing the interim interdict. Now, we'll get back to why we say that that was from the outset an inappropriate procedure in these circumstances. But it's in that context that the applicants say in paragraph 42, and responding to that criticism, they say this is entirely speculative. That is to say, the contention that the issues will be effectively much the same, if not absolutely the same, in the main application. They say this is entirely speculative. It's unclear what impact the court's decision in the HSS review will have, if any, on Part B of this application. The applicants in this matter still enjoy a right under Rule 53 to amend, to add to, or vary the terms of this notice of motion and supplement the supporting affidavit in its review application of the minister's decision. So at all times, all the parties were working within the confines of Part A, and the papers were crafted accordingly to the extent necessary. It was never contemplated.
Apologies, Counsel. Sorry to interrupt. Judge, I don't see Judge on the screen. Can I just ask that we take a minute to check if there's any issues?
Thank you, Depulo. I'm back now. Mr. Rosenberg.
Yes, thank you, Judge.
Apologies, I lost my feed in the building. I don't know what's wrong.
Thank you, Judge.
Let's just find out where I lost you, or the last point that I heard was when you indicated this application is effectively being heard by the same court hearing the interdict. In other words, this court hearing the interdict heard the main application.
Yes, yes. I'd made the point, and I don't know whether you'd missed that, Judge, that I'd referred to paragraph 10 of the answering affidavit, where the respondents made it clear that the affidavit was being filed in response to the Part A allegations, not Part B. It was confined to Part A. I referred the court then to paragraph 42 of the replying affidavit, where similarly the applicants recognize that the issues in Part B are likely to, or very possibly will be, developed and expanded in the context of the Rule 53 record. And that, of course, goes for both parties in the sense that the position that they have adopted in the Part A proceedings is a position that may and very frequently is evolved and developed in Part B. That was the point that I was making at that stage. And it's in that context that one has a situation that the court that is seized of this application is now seized with an application for final relief in these papers, has heard the two applications directed at setting aside the self-same decisions yesterday and the day before. The court heard those applications on a full set of papers with a complete set of annexures in which all aspects of the disputed decision were fully ventilated. The court will be aware that that decision was characterized by a great deal of inconsistent terminology by all parties concerned at various stages. And as was indicated to you yesterday, that decision was at various stages described by various parties as being a decision not to extend the ZEP permits, a decision to terminate the ZEP permits, a decision to grant a 12-month extension of the ZE permits, and a decision not to exercise powers in terms of Section 31(2)(b) to put in place a further exemption regime. Those correspond, or those various conflicting and often confused descriptions of the decision that was made and the power that was being exercised is one of the difficult issues that is going to detain this court. And the court will come to a conclusion based on the nature and consequence of the decision by having regard to the objective facts. The court will pay less regard to what various actors have described the decision as being, and having described what they understood the consequences to be. In certain instances, that may be of evidential value, but ultimately, the court is going to look at the objective facts bearing on the actual decision. And in the context of the power being exercised, will come to a decision or a conclusion in its judgment as to the true nature of the decision, what was and wasn't decided. And I'm making this point because crucial to that decision that the court has to make is, of course, the material that was before the minister on the date he made his decision. That's the starting point of the entire inquiry. And as the court will be aware from the proceedings in the two matters argued before that, that is in fact the memorandum that was prepared by the Director General dated the 20th of September 2021. The court will recall that that was...
Yeah, Mr. Rosenberg, I just want to find out where you're getting it now, because you're not going to re-argue the matter.
No, I'm leading, if I may just develop this point, it's leading up to what I submit is a crucial deficit in this case, and I'm about to arrive at the point I'm making.
I want to understand the basis upon which you say the applicant is precluded almost to proceed with this cause, that the application that they brought before the court today, and succinctly tabulated for the court.
Yes.
There was no note uploaded by the respondents likewise to forewarn the court of this. So I'm trying to, with the time allocated, we're trying to follow what you are saying.
Yes.
Right. Succinctly give us the pointers so that we can follow where this argument is going to develop to, because I also need to give the other side an opportunity to reply. Let me just find out, Advocate Toby, is there anything else that you wanted to raise?
No, my lady, I think it's really becoming a problem because we are now 28 minutes after 10.
Yeah.
And we either move our application for interim relief or our application for final relief. What is unacceptable is that the merits are being traversed before we've said anything.
Yeah. Okay, but I think Advocate Rosenberg understood now the court's position.
I do understand that. The point that I'm making is that the crucial document and material on which the decision turns is in fact the recommendation of the Director General, and it was in relation to that 4-page recommendation that the decision in question was taken on the 20th of September by the Minister, in terms of which he extended the permits. The point that I'm making is that in the present application, the final relief that is sought is relief directed at setting aside an application or setting aside a decision not to extend the regime. That is the relief that is sought in this particular matter as part of the Part B hearing. The relief that was sought in relation to the applications that you heard yesterday has been framed in the form of the orders sought as a setting aside of a decision to terminate, to grant a limited extension of 12 months and to refuse further extensions. Two decisions described in fundamentally different terms. The point that I'm making is that in the present situation, in the Part A papers, the evidential basis for determining and for this court to properly determine the nature and circumstances of the impugned relief is not present and hasn't been adequately and fully dealt with. That is the point that I'm making in relation to, and by contrasting, the evidential material before this court and the evidential material in front of the court in the two applications dealt with yesterday. It's simply not possible on the basis of the Part A material before this court to reach a properly informed final conclusion on the nature of the decision, when it was taken, and the details of that decision. It hasn't been ventilated in the affidavit.
The record that you are saying that informed the decision is not before this court. That's what you're referring to. We must not make a decision in respect of Part B. That's what you're saying to the court.
Yes.
Okay.
And of course, on that basis, it's submitted that the respondents would be prejudiced by the application to move for final relief in these circumstances on these papers. The proper course in these circumstances, given the decision not to move for interim relief and to move for final relief, would be to afford the respondents an opportunity to supplement their papers if in fact final relief is now sought.
Which will result in a postponement of the application.
That would result in a postponement of the application.
And if the application is to be postponed as far as cost is concerned?
That's an issue that can be dealt with in due course.
Thank you, Mr. Rosenberg. Sorry, Judge Malindi, do you have any questions to Mr. Rosenberg?
No, thank you, my sister. I have no questions.
Judge Moto?
No, I have no questions either.
Thank you. Applicant Guy Toby?
Thank you, my lady. The first point is that an applicant is entitled to move for final relief if the papers establish a clear right where they have brought an application for interim relief. The case law on the point is clear. We have provided the court with the case that is on point, which is the Majake versus Commissioner for Gender Equality case. But it affirmed a long-standing principle that if an applicant comes to court for interim relief, but from the answering affidavit, it becomes clear that the right is not disputed and the facts are common cause, they are entitled to move for final relief. Secondly, the law is also clear on the status of the record, all the way from Jockey Club. The record is not for the benefit of the respondent, it is for the benefit of the applicant. The applicant is entitled to waive their entitlement to the record and to move for final relief on the basis of the contents of the answering affidavit. Number three, the court will note the inconsistencies of the respondent. If you look at the answering affidavit, the objection is squarely taken to the interim relief on the basis that there is another related application which seeks the same relief. And I can show the court this clearly at the answering affidavit in case lines 00315, where the minister or the department says at paragraph 39 of the answering affidavit, the practical implications of the procedure that ZIF has chosen to follow is that on 5 to 7 October 2022, this court will hear the HSF review application and be called upon to make a determination of the review sought in that application. And at the same time, it will be called upon to determine the present claim for an interim interdict, pending a review of precisely the same decision or decisions. And if I can stop here, you would have noted that Mr. Rosenberg now adopts a different stance to that of his client, where he says that the decisions are different. His client says it's the same decision. Then in paragraph 40, they say it is submitted that ZIF's chosen procedure will result in a waste of judicial resources. It may result in conflicting decisions from the same court, and it is manifestly not in the interest of justice. Paragraph 41, further, the order sought in Part A to the effect that a ZEP holder may not be dealt with in terms of Section 29 and 30 of the Immigration Act, solely for the reason that they are holder of the ZEP, serves no purpose if regard is had to the directives of the minister, and then it goes on. The point I'm making here is that it's in fact the department that complained that there should not be a duplication of these hearings, and that the decision in the HSF case is the same decision that is sought to be challenged in our case. Number 4, there is no other document. Let us not be confused. There is no other document that will come from the department. The document they relied upon, they mentioned that in the HSF case, Mr. Rosenberg repeated it today. The minister's decision is based on the recommendation of the Director General. There is no other document. That's the only document. We have it. It's in front of us. We must simply decide whether or not a clear right is established on the basis of the decision by the Director General. The rest of it is simply to block the case for no particular reason. That is what is going on. We are facing a scenario in which the department is trying to postpone our case, not to get a hearing on our case, in circumstances where it complained that it should not be in the interest of justice to hear the interim interdict. Instead, final relief should be sought because in the HSF case, final relief is sought. So the reality, I'm afraid, Justice Collis, is that there is no obstacle to this court hearing the application for final relief, no prejudice. The law is clear, it's on our side. We can move for the application for final relief if the papers establish a clear right. We can do so with waiving the right to the record, and there is no prejudice in this case at all. So we would ask with the greatest of respect that we should now be allowed to move our case. If our learned friends have an objection, they will raise it when their turn comes. We've now already spent 40 minutes on what is initially described as a preliminary objection. When you listen to the preliminary objection, it's for arguing and forestalling what we are going to say. That is really unfair. Thank you.
It appears that Judge Collis has lost her feed. Ms. Taba, can you advise us whether to stand down or just to mute our devices until Judge Collis is back? What happens is that because they are sitting in close proximity to each other, they lose the feed together with the Ms. Taba, the registrar. So I would suggest that we just mute and wait for Judge Collis to come back.
All right.
Based on that, yes. Yeah, it's for the court to decide based the submission ye home affairs. Then I expect any document. Yes, when supplicant or that.
Could the other people who are not addressing the court please mute their microphones?
Judge, I've muted everyone that is not speaking.
Thank you very much, Ms. Maboho.
Thank you, my lady.
Thank you. I'm back now. Apologies for that interruption once again. We've requested IT to come through and sort out our feed. The challenge is, on the last occasion, my registrar was also kicked out from the proceedings, which is a challenge in its own, because she's responsible for the recording. So we must go back about 5 minutes or so just to make sure we have captured everything that was said.
Yes, my lady, I can't recall where I was when, because I didn't notice when we lost feed, but I can summarize what I'm trying to say to the court.
The issue is you were dealing with prejudice. There's no issue. There's no prejudice to the other side. The law is clear on that.
Yes.
And you are entitled as applicants to waive your right to the record.
Yes.
You made that point, in that you are not precluded from waiving that right. That's where we lost you, or when I went off.
Now, the point about prejudice, again, I can summarize that point. It is simply that there is no other document that is coming from the department. The department has told the court rather than us, on Tuesday and on Wednesday, that the sole recorder of the decision is the memorandum of the DG, which was then affirmed by the minister. In that case, we've got full access to it. In our case, it's the same position they have taken. When you consider prejudice, also you have to look at the prejudice from the side of the applicants. You cannot only look at prejudice which is claimed but not proven by the department. Look at the prejudice on the side of the applicants in the approach that is suggested by the department. Let us postpone the case. That is ultimately what they are trying to drive towards. Let's postpone the case. Now, we postpone the case in what circumstances? In circumstances where we act for 1,000 ZEP holders. The affidavit of the department confirms that on the 1st of July, they will potentially be rendered illegal in South Africa. Will all be rendered illegal, at least the 1,000 we act for, but there is 178,000. The 1,000 we act for, on the 1st of July, they are illegal in the country. Yes. And they've come to court not yesterday. This case has been around since 2021. And now they're not going to get their hearing. The case is going to be postponed. So one has to take a realistic view about where the interests of justice lie in a case like this. And you should be robust and not to entertain delaying tactics, which is really what this is by the state. So if you are to assess prejudice, where there is absence of prejudice because the sole recorder of the decision is one document, and you have to look at the prejudice of postponing the case in circumstances where we've been in court since 2021. And in the next 3 months, we are stateless. And being stateless means you are vulnerable to an arrest or vulnerable to a deportation. And then you are before 3 judges, specially assigned, and you don't get heard. That damages not just us, it damages the confidence of the public to the administration of justice. So you cannot postpone the case, you have to hear the case. You have to be robust in relation to the prejudice they claim, because there is none. You have to follow the law because there is no need for the record. We are entitled to ask for final relief where a clear right is established by assessing the answering affidavit of the department. So in summary, that's what we say. And we really ask that we should now get on with the case. It's 45 minutes after we should have started, and we are being delayed by the department. Thank you, my leader.
All right, let me ask you this, Advocate Nkaitobi. The other alternative is you proceed with your papers as it stands.
Yes.
On the Part A.
Yes.
You're not precluded from proceeding only on Part A.
Yes, I'm not precluded. I'm also not precluded, my lady, from arguing Part B. And my learned friend can say whatever he wants to say when his turn comes.
Yes.
What he cannot do is to stop me from talking, which is what he's trying to do.
I don't think he's trying to do that. The question I'm raising as the court, or posing to you as the court, is that you have a Part A that has been enrolled before the court. There's a full set of papers in respect of Part A, and you're entitled to argue your relief sought in Part A.
Yes, but my lady, I accept that. Let me not appear to resist that. But I am saying I am also entitled to urge the court to find for me in final relief. And my learned friend can make whatever objection he has when his turn comes. This is not a preliminary case.
Yes, I understand. All right. Thank you. Any questions, Judge Malinde? That you might have?
Maybe a question of clarity. So, Mr. Nkaitobi, if you proceed on Part A, it will be on, you say it will be on your papers and the respondents' papers as they are before court now, Mr. Rosenberg says, had they known that Part B would be traversed, they would have supplemented their answers to meet the allegations that seek, or the submissions that seek final relief. What's your response to that?
Switch on your mic.
Yeah. Thank you. Sorry, I apologize. So firstly, Justice Melinda, on Majake, a case is brought for interim relief, but the papers establish a clear right. The applicant is entitled to say, I want final relief. My learned friend says he wants to put in another affidavit. He can do that. No one complains about that. He can do that. If he wants to put another affidavit, he can do that. The court will take that into account. And I'm not going to stop him from putting extra evidence before the court if he wants to do that after the hearing. What I am protesting against is that we are not to be heard today on final relief. I will move the application for final relief. The court will decide once I've done that whether or not there is enough material to grant final relief or not, or whether or not there is enough material to only entertain Part A. So none of these are preliminary. These are all arguments that go to the nature of the relief that are sought at the end of the hearing.
And in your papers, you used the phrase that Mr. Rosenberg repeated, that the court may take a judicial peek into Part B. Will the court be justified to do that if Part B is not set down for today?
The judicial peek is relevant for Part A. What I am saying is that on Madake, the facts really do establish an entitlement to final relief. And right. Justice Melinda, just remember what is this argument made by Mr. Rosenberg. Just interrogate it for half a second. He says his complaint is that the decision has been described in different ways. Sometimes it has been described as a decision not to extend the ZDP. Sometimes it has been described as a decision to extend further privileges. Sometimes it has been described as something else, 3 or 4 different ways. What does that have to do with whether or not the facts are established that would constitute a basis for final relief? So the characterization of the decision is a matter for legal argument. He can make all of the points he was talking about today in legal argument, that one document describes the decision differently from another document, and he can make whatever submissions he wants to make about the implications of that decision. And one must remember that they are the ones who protested about interim relief. So when we now take up the invitation, they're protesting again.
Thank you very much. Thank you, my sister.
Thank you. That's Mota.
Yes, Councillor Nwatobi, if I understand you very well, you are effectively saying that you want to give them what they're asking for in their answering affidavit. Yes. That if we proceed on an interim basis, that like you had initially wanted to proceed, there would be an issue of res judicata and issue estoppel. Now you're trying to avoid that, if I understand you very well. But you go further than that. You are saying you have met all the Sitlogelo versus Sitlogelo requirements in your estimate. You have a clear right, there's an actual injury, and you do not have a satisfactory relief, yes, alternative relief. Yes. Now, the question that I have is, they are saying with all that, that's well and good for you, because you are ready. But with us, we have not been able to ventilate these issues either by way of an affidavit, meaning to attack your clear right, to attack your injury, to attack all that obviously needs to be attacked. And you are saying that's up to them. If they want to file a further affidavit later on, they can do that. You're not going to run their case. Doesn't it put the court in an invidious position where now it will have to decide if they say, we want to file further papers. We understand that you're not proceeding with your Rule 53 as well, in that you're not waiting for the statement, which is for the benefit, correctly pointed out, of the applicant, not basically of the respondent. So you want to proceed. What do we do with their request if they were to request that they want to file further papers? I don't know if you follow me.
No, I do follow. Well, I think I do follow you, Justice Morton. I understand precisely what you're saying. All I'm saying is this request to file supplementary papers happens all the time. Whether it was an interim relief application, the party comes and says, look, the point has come, I want to file supplementary papers. That has never been used as a basis to block a party from running their case. If ultimately you decide that it's in the interest of justice to grant them leave to file, do that. I cannot stop them from doing that. What I'm simply saying is that this morning I should be allowed to argue my case, move for my right, my clear right, final relief. My learned friend will come and object to it and say it's inappropriate, it's prejudicial, etc. There is no reason to have an hour spent on a so-called preliminary objection on a matter that really goes to the merits of the case. If you are ultimately satisfied that I've met the requirements for final relief, there is no prejudice to the respondents, you may grant final relief without giving them a chance to put a supplementary, or you may give them a chance to put a supplementary. That is all your discretion. If ultimately you come to the conclusion that the best approach to take is that you should only entertain interim relief, notwithstanding the objections that have been raised by the applicants, so be it. But what we are fundamentally opposed to is a stratagem.
Justice Collins, may I reply at this stage very briefly?
Just hang on for me. I need to find out whether that's the only question that Judge Mota wanted to ask.
Yeah, no, so far that's I'm okay. We can move on.
Thank you. Your reply, Mr. Rosenberg?
Thank you, Justice Collins. May I emphasize very firmly that this is not a stratagem, that in the first instance, in as much as counsel insists that the exigencies and urgency of the matter is such that it's imperative that the application for final relief goes ahead today for the reasons he's indicated, you'll be aware that there are 3 applications for final relief on this very issue, 2 of which have been argued by you, in respect of which the rights of all 178,000 ZEP holders are being presented to you. So whether or not the final relief in this matter gets heard today must be seen in that context. Secondly, it's not a question now of the applicant yielding to what the respondents had always wanted. The respondents at the outset adopted the approach that seeking interim interdictory relief was an inappropriate procedure to adopt in these circumstances, given the timelines of the various applications. The various applications, in particular the HSP application and the COMSA application, were launched in the middle of 2022, June 2022 HSF, COMSA 20 July 2022, where it sought to intervene. ZIF was launched, or the present application launched at essentially the same time. But rather than adopting an approach of seeking to intervene and effectively consolidating, where essentially the same challenges were made to a decision which happens to be described in contradictory ways, but it's clearly the same decision, at that stage, it was appropriate that the applicant in this matter should not have persisted with an application for interim relief, particularly when it persisted with that application over a period beyond 5 October last year, throughout the 5 or over 6 month postponement of the hearing up to today. and it is only effectively 1 court or 2 court days before this matter was due to commence that the applicant seemingly appreciated the impact of the point that had been made all along, that it made no sense and would give rise to any number of procedural paradoxes and difficulties for it to be arguing for interim relief and demonstrating prima facie prospects of success in a review, where this very court was finally determining the review, and that they would then go on to a Part B in due course, well, when this court had already determined the review in Part B. The procedural inappropriateness of that was obvious, and it wasn't recognized when it should have been. What ought to have happened is that the applicant in this matter, whether before or shortly after April last year, should have done what it did the day before these proceedings commenced. It should have recognized that asking for interim relief in this context was inappropriate. It should either have intervened, or it should have made it clear that when his application was continued to be effectively consolidated with these applications for simultaneous hearing by the same bench, it should have done what it seeks to do now belatedly at the last moment, to in fact move for final relief, and the adjustments to the affidavit could have been made well in advance. And we would then have got rid of the inconsistencies that in fact you face today. You're now faced with an application for final relief in terms of which a decision is described in terms entirely different from the decision which is the subject of the draft orders that were presented to you yesterday. We know it's the same decision, the September 2021 decision, but all of those problems are created entirely by the applicant's choice of an inappropriate procedure and the applicant's failure to do something about it timely. It is not, and I must emphasize this, it's not the minister just seeking to delay. This matter is not being delayed. You've heard the matter yesterday, and you are enjoined to come to a decision as with all speedy deliberation. Postponing this matter is not going to postpone any evil day for the minister whatsoever.
Yeah, but this is what I want to get to. So as far as I understood your argument, you're not seeking a postponement per se. You're saying if they wish to proceed with the Part B portion of their relief, then you would want to have an opportunity to supplement your papers if needed, and that will necessitate a postponement. But you are ready to proceed to argue the Part A.
We are ready to proceed to argue Part B, but we'd make the following submissions and then I will close. We will argue, as we've argued in the heads of argument up to now, that moving for interim relief in these circumstances is inappropriate. There was and remains an alternative remedy. And secondly, we've presented with submissions and a draft order in terms of which we are told that the applicants are not pursuing interim relief, they are pursuing final relief.
Yeah, but the point I'm making, Advocate Rosenberg, is you are ready to argue even that argument. You are ready to argue it.
To argue which relief? The interim relief?
If the court has to make a decision now, not so. You confront it with a request, we have to rule on it.
Yes.
If the court rules that the applicant is to proceed only in respect of Part A, the respondents are ready to argue that point.
The respondents are ready to argue the Part A relief if the Part A relief is to be entertained and reinstated, as it were.
Well, it's still before the court. The notice of
Yes.
motion has not been amended, sir.
Yes.
Okay. Is there any other further arguments in reply?
The only further point that I would make is the authorities in relation to obtaining final relief where a clear right has been established in interim proceedings are authorities which generally arise in a totally different context. And the one authority that has been referred to by counsel for the applicant, the decision of this court in 2010 of Majaki was a situation where there was an application by a dismissed employee for reinstatement. That was the interim application. As I read the decision, it was contemplated that in due course there would also be a review of the proceedings in terms of which that employee had been dismissed. And in the course of that judgment, the presiding judge commenced his judgment and his analysis by the circumstances of the dismissal of the employee in question, and came to a conclusion, a firm and final conclusion, that in fact the employee in question had been unlawfully dismissed. And in paragraph 87, a firm conclusion was reached that the contract of employment was terminated unlawfully. The applicant is entitled to reinstatement as a matter of contract, and although reinstatement is a discretionary remedy in employment law, it is awarded here because of the infringement of the rights in question. And in that matter, then, the court came to a clear final view on the central issue of whether the applicant was entitled to reinstatement, and it didn't seem to then be necessary in those circumstances to commence a contemplated review, and it wouldn't have been appropriate because the court had come to a final decision. That's slightly unusual approach, but the court was able to come to a final conclusion on the issue of dismissal, and it did so. This is entirely different in a situation where one is dealing with prospects of success as a possible element of the requirements for interim interdictory relief, where the merits of the review are always intended to stand over for later determination. And that's where the prejudice lies.
Okay. Sorry?
Mr. Rosenberg,
Oh,
as my sister has indicated, if you can hear me.
Yes.
What you've just traversed now will be your answer to Mr. Ngugaitobi while moving Part A, and he urges the court that nevertheless final relief has been established in the papers as they are in relation to Part A, and then you may then make those submissions. Is that not so?
Yes, if the court says that the argument can properly proceed for final relief, and we are going to argue for final relief, I would then have to repeat my submissions as to why, in the circumstances, it's not appropriate on these papers and the nature of the prejudice.
Yes, thank you.
Thank you, Mr. Rosenberg. Any questions on the side of Judge Mota?
No, no questions.
Right. Can we take an adjournment at this stage then, so that we can have regard to what has been placed before the court, and then we'll reconvene after tea. Thank you.
Okay.
How?
Yeah.
He unmuted it.
Hey, that one is a box.
Yeah. Judge, then it should be saying, give the people of Sudan.
Please mute yourselves in code 2B.
Oh, all right, thank you. Morning.
Thank you, my lady.
Thank you.
My lady, I confirm resumption of proceedings for case number 006-386 of 2022. May it please the court.
Thank you. Are all the parties online?
So, Advocate Rosenberg,
Yes, I'm online. Thank you, my lady.
and there's the applicant's counsel as well, my lady.
Okay. And Judge Malindi, I don't see him. Is he online?
Judge Malindi is online, my lady.
Okay, thank you. Thank you. The ruling of the court then. The present application consists of a part A and a part B. Part A is to the notice of motion, wherein the applicant seeks an interim interdict pending the determination of part B on a future date. This court was presented with a full set of papers in respect of part A and thus accordingly prepared for the hearing in respect of part A. The parties prior to the enrollment of the application for this week met with the Deputy Judge President of this division for the allocation of these specific hearing dates. And at all times, it was the position of the applicants that only part A of the application is ripe for hearing. This is the basis upon which these dates were allocated and subsequently the enrollment prepared. In addition to this, the parties were directed by the Deputy Judge President to prepare a joint practice note for the court, wherein they were called upon to identify the issues that this court was called upon to determine. Therein, the parties clearly stipulate that this court was called upon to determine part A, that is the interim relief of the notice of motion, during these dates are allocated. Now, on the 6th of April 2023, this is with no business day to the date of the hearing of the first day of the hearing of this application, the applicants then filed a supplementary note. In this, a supplementary note to the heads of argument. In this note, they now contend that this court would be entitled to grant them final relief. Coupled to this, they also on the 12th of April 2023 uploaded a proposed draft court order for the court, wherein not only a final interdict is now being sought, but also a final determination in respect of part B. This, the respondents contend, is prejudicial to them. The evidence presented by the respondent does not support this relief now sought in respect of the proposed draft court order by the applicants, nor has the respondents been given an opportunity to supplement their papers timeously where necessary and prior to the hearing date of today. And it would therefore be impractical also for the respondents to do so now. The prejudice as such to the respondent is manifest. Consequently, they request a postponement of the application if this court is inclined to consider granting final relief now contended for by the applicants. In our view, the applicants are not precluded to proceed with part A of the application, nor is the respondents precluded to present its case in respect of part A, as this is, in our view, what is before us today. This court is mindful of the urgency of this application to be determined, and as such does not deem it prudent for any part of this application to be postponed as contended for by the respondents. It is for this reason that this court finds that part A is to proceed today, as this is the portion of the notice of motion that have been enrolled for for adjudication by this court.
Thank you, my lady.
Thank you. You may then proceed.
Thank you, my lady.
Yes,
thank you, my lady. The court has seen the heads of argument that have been filed in support of Part A. And the court also knows the test for an interim interdict. It is a fourfold test. We have to satisfy the court that we have a prima facie case. Secondly, we have to satisfy the court that the balance of convenience favors the granting of the application. Thirdly, we have to satisfy the court that there would be irreparable harm if the application is not granted. And fourthly, that there are no satisfactory or realistic alternatives to the interdict. What I am proposing to do, because there is in fact a substantial overlap between what was argued on Tuesday in support of the final relief and what has been argued, what will be argued now in respect of the prima facie case, is not to repeat most of what was argued by Mr. Badland, but to pick up on specific topics that the court is urged to take into account. No longer, luckily, for the purposes of establishing a clear right, but only for the purposes of establishing a prima facie right, even though it may be open to some doubt. So, on the prima facie standard, the first question that has been debated at length is the question whether or not a decision was taken at all. The argument that was raised on Tuesday and Wednesday, by the department is that it took no decision. What in fact happened was that the ZEP regime came into to an end by operation of law. So I want to look at what has been pleaded for lesser standard and show the court that it is an impossible argument to sustain that no decision was taken. The second point I am going to show is what is the correct characterization of that decision. Some time was taken as to whether or not the decision is liable for review under the Promotion of Administrative Justice Act or only under the principle of legality, or whether its correct character is that it is a mere policy with no practical consequences. That is crucial in order for the next topic, which is on what basis do we seek to challenge the decision. The court will recall that, unlike Mr. Badlander's clients, my client challenged the decision primarily on ultra-virus. They say that the decision is inconsistent with Section 31, subsection 2, subsection B of the Act. Now, I will come to this topic because you would have heard during the course of the argument that the department says that it did not invoke Section 31(2)B because this was not a withdrawal. But I will show you on the pleadings that in fact the department says it invoked Section 31(2)B. And I will show you by reference to authorities, all the way from Harris up to most recently the case of Langa versus Premium, that where a department chooses a section and it says we are taking this section this action in terms of section so and so, if it is subsequently established that the prerequisites of that section were not fulfilled, the department is not entitled to say that the decision is nevertheless authorized by a different section. And so the only prism through which to assess the validity or legality of the decision on a prima facie basis is whether it complies with Section 31, subsection 2, subsection 3 of the Act. We admit that it is a straightforward inquiry. The minister has cited the provision, but what he did is not authorized by that provision, and therefore he acted ultra-virus. The second reason why the Section 31(2)B argument is of some significance is that if it is correct, as the minister says in the decision itself, that he relied on Section 31(2)(b) of the Immigration Act, the jurisdictional prerequisites that are in that section is good cause. The minister can only withdraw the permit for good cause show. Now, it's crucial to focus on the language of the statute, because good cause is not the same thing as reasonableness. It is not the same thing as rationality. It is, in fact, a much wider standard that invites the court to make a value judgment as to whether or not on the facts good cause has been shown. We will show that no good cause has been shown. Then we will also argue that the decision in any event is an irrational decision. In fact, it's worse than irrational. It is an arbitrary decision. What we will say in this regard is that the primary justification why the DZP, later to be called the ZEP scheme, was introduced was precisely because of the declining economic and political situation in Zimbabwe. That means that it can only be withdrawn for reasons that are related to the economic and political instability in Zimbabwe. What we have here is a constellation or a random assemblage of justifications that have no bearing to the justification for introducing the scheme in the first place. And I will take the court carefully through the justifications that have been given by the department to illustrate why, on a prima facie basis, you would be entitled to regard the decision by the government as an arbitrary assemblage of unrelated considerations. So if I am correct that good cause has not been shown, and I'm correct that the decision is in fact arbitrary and fails reasonableness or rationality, then of course the court would find that we have established that there is a prima facie basis to say that when the review is argued or heard, it will be successful. Once I've done that, which is around the grounds of review, I will look at the impact. In fact, interestingly, the approach taken by the court is the most relevant here, because when we take a debate around the impact, the simple question is, on the 1st of July, 2023, what will happen to the 178,000 recipients of the ZEP program? What will happen to them? It is common cause on the fact that they will be rendered overnight, they will be rendered illegal immigrants in South Africa. That would mean either they deport themselves voluntarily, but the facts show that they are unable to return to Zimbabwe for the reasons that would be articulated. What would then mean is that they would be liable to deportation, forced deportation. Alternatively, they would be liable to arrest because they would have violated the provisions of the Act. What is interesting here, and that goes into this issue about whether or not we have shown that there is, in fact, irreparable harm. What is interesting here is that the government's argument on this point is to say that they have a discretion whether or not to deport people. They have a discretion whether or not to arrest people. And what they say is that we must be satisfied about the existence of that discretion, but they make no commitments about whether or not that discretion will be exercised in a way that would not invoke Section 29, Section 30, or Section 34 for that matter, of the Act. So in circumstances where the legal consequences are plain, a deportation or an arrest, it is absolutely not satisfactory for the government to say you must rely on the fact that we may, but we are not committing. We may elect not to deport, we may elect not to arrest. So it's quite plain that when it comes to irreparable harm, that there is in fact irreparable harm. Government also argues when it comes to alternative relief. The government says you may apply for one of the other visas, a work visa, a study visa, a business visa. It says you may apply for those visas. But in doing so, it overlooks the very reasons why the ZEP program was introduced in the first place. It was introduced precisely so that the holders of the ZEP do not have to go through the rigmarole at the Department of Home Affairs. And in fact, it also overlooks its own factual scenario. Because when you examine the reasons that it has given, the government says its budget has been reduced and it is unable to handle the volumes of the asylum applications. So it has no resources to handle these applications. And yet it is instructing 178,000 people and potentially their dependents. And we heard from the department on Tuesday that those dependents, you could multiply that by 3 or by 4. So it is instructing literally tens of thousands of people to go to their offices in circumstances where on the papers it is common cause that they lack the capacity to manage. So we are headed, sleepwalking in fact, towards a human catastrophe of monumental proportions, unless the court intervenes by granting an interim interdict and staying the consequences of this catastrophe that is impending. Finally, when it comes to balance of convenience, we simply cannot fathom why the government says the balance of convenience favors it. There's just no prejudice to the department at all. No prejudice at all to the department. The only argument we understand, and it was raised prior to the commencement of this address this morning, we will no doubt be treated to it again, is that there is another application by the HSF that is before this court. But again, the government must take a position about this HSF application. It cannot say that application is irrelevant because it deals with a different decision, and then say in this case that application is relevant because it deals with the same decision. It is either the applications are separate or they are not separate. But in any event, that is not relevant to what we are dealing with here. Because even if your ladyship and your lordships granted the HSF review, the need for an interim interdict continues to remain because of the potential for an appeal. Even if you granted that review together with the interdictory relief, because all of that under Section 18 and Section 17 of the Superior Courts Act gets suspended by the mere lodgement of a review application. So which again takes us back to where we are. We have a scenario in which 178,000 people become immediately vulnerable to a deportation or an arrest on the 1st of July. So in fact, this is an appropriate application even in the light of the HSF application. Let me then go to what I wanted to start with, which is why do we say we have a very strong prima facie right to the relief that is sought. Let me first address this issue about a decision. The question whether a decision was taken or not taken, or whether or not the ZEP lapsed or elapsed by operation of law, is a question of fact. You have to look at the evidence. What does the evidence show? There are at least 5 portions of the record that make it absolutely clear the minister took a decision, says he took a decision. Not only does he say he took a decision, when you look objectively, he in fact did take a decision. The first is in paragraph 12 of the answering affidavit, which you will find at page 003/9. And in paragraph 12, the minister says, well, not the minister, the opponent, I think it's the DG to the affidavit. It says, all the approximately 178,000 ZEPs expired on 31 December 2021. And then it says, in September 2021, that's 3 months prior to the expiry, the minister decided that he would not be extending the exemptions as had hitherto taken place. So the minister tells us, the DG tells us in explicit terms that the minister decided that there would be no extension as had taken place before. Secondly, in the same affidavit, at paragraph 134, at page 003/39, the minister returns to the theme of decision. He says, as I have indicated, the minister decided not to extend the exemption as had been done hitherto, but rather to issue a directive extending the validity of the permits to 30 June 2021, as he was entitled to do in terms of Section 31(2)(b So we have, again, under oath, a statement of fact that the minister made a decision not to extend the exemptions as it had happened before. But if that is not sufficient, when we look at the decision itself, which is the original source, we find decision in 3 parts, which is at 003/92, which is the notice signed by the DG to all Zimbabwean nationals granted exemptions in terms of Section 31(2)(b). And there we find at paragraph 2 of that notice, where the Director General says, kindly note that the Minister of Home Affairs has exercised his powers in terms of Section 31(2)(d) of the Immigration Act not to extend the exemptions granted in terms of Section 31(2)(b) of the Immigration Act. And then in paragraph 7 of the same document, it says the decision of the minister was taken due to inter alia the following reasons. So that's the 3rd part, where we see, again, a confirmation that a positive decision was taken either to do something or not to do something. It was not a situation where something is not decided, but the operation of law kicks in. The 4th part is at 003/94, which is the longer statement by the minister, which records submissions made by the Director General. And at 003/94, paragraph 11 of that statement, which we were told this morning by Mr. Rosenberg, that that's the best recorder of the decision together with the recommendation of the DG. And in paragraph 11 thereof, it is stated, in or about September 2021, I decided to approve the recommendation made by the Director General not to extend the exemptions to the Zimbabwean nationals. And then in a letter, a response to the stakeholders, and you will find 3 copies of the same letter responding to different stakeholders, basically repeating the same information. But you will find that at 003/96 at paragraph 2, this is now a response to the stakeholders, where the DG says, kindly note that the Minister of Home Affairs has exercised his powers in terms of Section 31(2)(d) of the Immigration Act not to extend the exemption granted to you in terms of Section 31(2)(b) in 2019. So we have at least 5 portions from the minister's own affidavit about what he decided to do. And we cannot speculate about this because it's recorded clear, black and white. And I heard Mr. Rosenberg anticipating the argument by saying there are variations of the recordal of the decisions. There are no such variations. The minister is explicit, the DG is explicit. The minister has made a decision not to extend the exemptions. So it is quite plain on the first argument that a positive decision was taken by the minister. And so, as interesting as the debate may have been about penalty and fraud versus NPA, it is irrelevant because the evidence is manifestly clear that a decision was taken by the minister. And so if the minister is clear that he took a decision as a matter of fact, on what basis does he say he took the decision? He says he took the decision in terms of Section 31(2)(b) of the Act. He says so in various parts of the record. He says so at page 003/96, paragraph 2. Kindly note that the Minister of Home Affairs has exercised his powers in terms of Section 31(2)(d) of the Immigration Act not to extend the exemption granted to you. So he tells the person asking that under this section, I've exercised the following powers. And where the minister himself is speaking, not the DG, which is at page 003/94. The minister also invokes section 31(2)(b), and where the DG speaks, giving that notice, which is 003/92 at paragraph 2. Kindly note that the Minister of Home Affairs has exercised his powers in terms of Section 31(2)(d) of the Immigration Act, not to extend the exemptions granted in terms of Section 31(2)(b) of the Immigration Act. So two things are clear at this point of the case. One is there is a positive decision taken by the minister. We are unambiguous about that because the minister tells us himself. Secondly, the statutory basis for the decision is stated by the minister to be Section 31(2)(b). In other words, what the minister is saying is that he believes or is advised that the authority that he has not to extend the ZEPs flows from Section 31(2)(b), and he is exercising that authority. So if we know these two elements, what implications do they have on the characterization of the decision in relation to whether it is of an administrative nature or it is of an executive nature? Firstly, we have to look at the definition of an administrative action under PAJA, because it's the only way we know whether or not a decision falls within the corners of PAJA or outside of the corners of PAJA. Now, again, the three judges listening to this case no doubt have had this argument before about whether something is inside or outside of administrative action, but it's usually helpful to just go back to the basics, particularly in the light of so much debate that has taken place about the character of the decision. So the definition of an administrative action actually admits of no confusion. An administrative action under Section 1 of PAJA is any decision, we know a decision was taken, or a failure to take a decision. So even if no decision was taken, there would have at least been a failure to take a decision to extend. But here we don't have to go there because we know on the facts that a decision was taken. So taken by who? By an organ of state. So we know that a minister is an organ of state. And under sub 1 and sub 2, exercising a power in terms of the constitution or a provincial constitution. We know here that the minister did not say he was exercising a power under the constitution or a provincial constitution. And then it says or in Roman figure 2, exercising a power, a public power, or performing a public function in terms of any legislation. So that's exactly where the decision fits. It is an exercise of a public power. It is a performance of a public function in terms of the Immigration Act. And when it says in terms of any legislation. And the minister says so himself, he says, I have elected or I've decided not to extend the ZEP program under Section 31(2)(b) of the Immigration Act. So that falls squarely under a decision, organ of state, public power, or public function under legislation. And then it goes further, which says, which adversely affects the rights of any person. Now, plainly, we have two categories of rights that are implicated here. And again, there can be no debate of it. One is a set of constitutional rights which exist whether we have the ZEP program or we don't have the ZEP program. For as long as a person is in South Africa, they are entitled to constitutional protections unless the Constitution specifically limits the protections only to citizens. But where it says anyone, everyone is included within the ambit of that protection. So when rights like dignity, separation from family, sometimes life, when those rights are asserted, they pre-exist the ZEP program, and plainly they are affected. So that's the higher order set of rights. It's rights that are conferred under the Bill of Rights, under the Constitution, which have been asserted fully in the founding affidavit. But there are also other rights, which is a second order layer of rights. Those are the rights that come about because of the exercise of the ZEP program. Because the ZEP program gives you the status that you would ordinarily not have. You would have been treated as an illegal immigrant. What it does, it transforms your position in South Africa from being an illegal immigrant to being a person that is recognized by law to be in the country lawfully. But there are consequences that flow from being in the country lawfully. You can work, you can study, you can open a business. And those are the three core entitlements that you would have because you are a holder of a ZEP. Both of those rights, the higher order Bill of Rights and the lower order rights that flow from the possession of a ZEP are impacted adversely because they terminate. They are impacted adversely by the decision that has been taken by the minister to terminate the ZEP program. And then it says, and which has a direct external legal effect. Now, in the early days of PAJA, there was a big debate about what direct external legal effect means. But what's clear here is that the decision need not be an inward decision. In other words, a decision that affects the arrangements internally in the department. But it must be a decision that affects a person outside of the department, affects the rights outside of the department. And that's what direct external legal effect is about. So when we look at these 5 definitional elements of PAJA, the decision meets all of these 5 definitional elements. And then there is still a 6th element, which is, does it fall under the exclusions? Does it fall under the exclusions of PAJA? And it plainly doesn't fall under the exclusions of PAJA. It's sure it is taken by a member of the executive, and sure it is endorsed by cabinet. But at the end of the day, it is an implementation of a legislative authority through an administrative fiat, through an administrative order. So it is closer to the field of administration. It is not a minister announcing policy. Today, the policy of South Africa would be in support of Russia and not in support of America. Or the policy of South Africa would be, we would rather ban coal or move into renewables. That's not what we are debating here. What we are debating here is an administrative decision with practical consequences for the daily lives of 178,000 human beings. So it meets the 5 elements in PAJA. It does not fall within the exclusion. So when one hears the argument about policy, we should not get confused. This is not a policy announcement. It is an enforcement of a decision with immediate consequences. And there is nothing else that the government needs to do. The government has done its job right now. It's made an announcement that when the ZEP lapses, it will not be renewed. And that is what has been referred to in the government's own papers as a decision not to extend. So it's single, it's composite, it's final, it's complete. What then happens are the mere legal consequences, legal and practical consequences of that decision. And there are many of them. And the founding affidavit sets this out, and I'll come back to them when I deal with the question of irreparable harm. There are many of those consequences.
Let me just understand, Advocate Nkaitobi. So you're not attacking the fact that there was a policy decision taken. What you are attacking is the implementation of that policy decision.
What I am suggesting, thank you, Justice Collis, I'm glad you've raised that question, because this distinction between a policy and the implementation of the policy has bedeviled much of the argument. There is only one decision here, and that decision may be a manifestation of policy, because one must not, one decision. It's not as if the government sat there and said, let's decide a policy on nuclear, or let's decide a policy on Russia. What it decided to do is, let's terminate the ZEP program. One decision, let's terminate the ZEP program. That decision to terminate the ZEP program constitutes the articulation, the enforcement of policy in one. It's single, it's composite, it's one decision. So there is no policy that does not affect any rights that has been announced. It's an announcement of a policy decision, if it is to be correctly characterized as such, which has an immediate impact on rights. So let me go back to this debate on policy, because again, there is some conceptual problems with it. When one says,
Mr. Nkaitobi, before you do that, this will be incorporated in your response. By exercising his powers under section 31 brackets 2 brackets B, the minister took a decision which had the impact, or potential impact, which is a subject of debate in this matter. But at the same time, that decision did away with special dispensations for Zimbabweans, the ZEP. Am I correct?
Indeed.
And then when you answer my sister on the delineation, as you propose to do between policy and exercising the powers under section 31 brackets 2 brackets B, could you then assist us to know whether your client is seeking relief because that exercise or that decision had the impact of doing away with policy, or whether merely on the impact that exercise of power resulted in?
Yes, thank you, Justice Malinda. I should start by answering your question because it will take me to the question asked by the presiding judge. So my client says, we are in court because the decision that you took had an immediate impact on our existing rights. Rights that exist by virtue of us being in South Africa under the Constitution, and rights that exist by virtue of us being holders of the ZEP permits. The rights by virtue of being holders of ZEP permits have actually been rendered redundant as we speak. They are gone. The constitutional rights may not be rendered redundant in full, but they will substantially be encroached. So we seek relief because the decision that has been taken, which is a statutory decision on the minister's own show, statutory decision. It's not a decision that is a policy decision in the abstract. It is a statutory decision under section 31(2)(b). And now let me come back to Justice Collis's question. The point I'm making, Justice Collis, is that this concept of policy can manifest in different ways. Policy may be in a statute, it may be in the Constitution, or it may be in an administrative decision. But the mere fact that an administrative decision is informed by policy consideration does not on its own transform or the decision, take it out of the realm of administrative review. The only debate that you have to take into account is whether the decision that has been taken fits the definition of administrative action under PAJA. If it fits the definition of administrative action under PAJA, and as I've tried to show, then it is a decision vulnerable to challenge under PAJA. It may be that in your exercise of your judicial authority or judicial review, you defer because of a high policy content. But it is not a scenario in which once policy is invoked, therefore the judges cannot intervene. If it is an administrative action under PAJA, obviously you are entitled to review under PAJA. If it is not an administrative action under PAJA, you may be entitled to review under legality. The mere fact that it is an announcement of policy. If it is an announcement of policy that is ultra-virus, you should strike it down. If it is an announcement of policy that is irrational, you should strike it down. Because under pharmaceutical manufacturers, paragraph 90, all the exercises of public power are subject to the principle of legality. And again, if it is an announcement of policy that infringes on existing constitutional rights, you should strike it down. Two examples have already been made. Well, one example was made by Mr. Badland. I want to add another one. So one is the treatment action campaign. If you remember the facts of treatment action campaign, it was the policy of the government to roll out nevarapine, which excluded pregnant women, which therefore exacerbated the problem of mother-to-child transmission. But it was a policy.
Before you continue with that, if I may jump in, Counsel, doesn't Mutau's judgment also help us here?
Yes.
If you look at what Kambembe J said in determining whether it's a policy or it's administrative action, don't you look at where the source of the power is from?
Yes.
So if you are locating it within the 31(2)(b), which is a legislation,
Yes.
then that's a clear indication that this, what we might be dealing with, is an administrative action, as
Yes.
opposed to what the judge spoke about when the source of the power is the Constitution. Could that help as well?
Indeed, it's absolutely vital because that's the third decision I was going to deal with. I just wanted to dispense with this notion that policy is outside of the realm of judicial review. So the first point is when policy is articulated through administrative action, it is subject to judicial review under PAJA. When policy is articulated through legislation, it may be subject to judicial review under PAJA if it fits the definition. It may also be subject to judicial review under legality, and when policy is not articulated anywhere, for instance, nevarapine, there is no legislation that tells the government whether or not to extend nevarapine to pregnant women. Nor is there any policy that tells the government that when it designs housing policy, it should take into account the interests of vulnerable people. But in both of those cases, the Constitutional Court explicitly says exercise of policy powers by the executive is subject to constraints through the Bill of Rights. So there are three levels of constraints to what is referred to as policy. There is administrative review under PAJA, if it falls within the definition. There is the rationality review, if it doesn't fall under the definition. There is also the Bill of Rights, which is also a constraint to the exercises of policy, depending on how it is manifested. In this case, we don't have to get into that interesting conceptual conundrum because the department has told us that it is exercising the powers it has under Section 31(2)(b). And in Motau, as Justice Mota points out, when you look at what is the source of the decision that is being exercised, the source of the decision is the statute. What is simply happening is on the government's own showing, it's bringing into life its power under the statute. It's terminating the ZEP, and it's at the most lower level. It's coming into operation on people. So this, again, I make the example. This is not a scenario in which the government says, our policy on nuclear is the following, but it then takes no decision that would impact on people. This is a case where the decision is contained in the same instrument, Justice Malin, same instrument that then takes away existing rights. So there should be no confusion around this policy debate. The fact of the matter here is that we are dealing with the outward manifestation of a statutory power under the Immigration Act. It's precisely what PAJA is designed for. When the minister says, I have a power under Section 30, I'm exercising it. That's what PAJA is for. That's why PAJA says the second character of administrative action. The first one is that it must be a decision. Second one is that it must be a decision taken in terms of a legislation. Whether or not requirements in the legislation are met is irrelevant to the characterization of the decision. It may be that they've wrongly invoked the legislation, or they've violated the procedures in the legislation, or they've acted ultra vires the legislation. But
they quoted the wrong section, or they could even have quoted the wrong section.
Or they've quoted the wrong section. But what is common cause is that they are acting under that section. And that is what brings it under administrative action. So this entire debate is interesting, but it is irrelevant because the short answer here is that they are exercising a power under legislation. Now, once we have sorted out then those two problems about the nature of the decision and whether it's within or outside of administrative action, really the only question that remains is, are they within or outside the purview of the section that they have cited? Now, I promised the court when I began that I'm going to refer to two cases which say, when you take a decision and you locate that decision under a section, you are precluded from subsequently saying to the court, I may not be within that section, but I have the power elsewhere. You are bound by the section that you chose. The first case is Minister of Education versus Harris. it is reported in 2001, volume 4, SA 1297, and it's paragraph 18. And it's a unanimous judgment of the Constitutional Court where there was also in that case an interesting debate on policy, but it eventually became immaterial to the determination of the case. It says in paragraph 18, in this case, there is no suggestion in the affidavits filed by the minister of an administrative error. On the contrary, the notice in the present matter not only cites section 341 of the National Policy Act 3 times as the source of its authority, it identifies itself with the act by means of its heading, draft age requirements for admission to an independent school policy. There can be little question then that the provision was deliberately chosen. It might well be that those responsible for drafting the notice had doubts about whether the powers under section 5.4 of the Schools Act could be used in respect of independent schools, a matter that I expressly leave open. They might have had other reasons for choosing to issue the notice under section 3.4 of the national policy. It is not necessary to speculate. What is clear is that they consciously opted to locate the notice in the framework of section 3.4 of the National Policy Act. The result is that it is now not open to the minister to rely on section 5.4 of the Schools Act to validate what was invalidated by 3.4 of the National Policy Act. The otherwise invalid notice issued under the National Policy Act can therefore not be rescued by reference to powers which the minister might possibly have had, but failed to exercise under the Schools Act. The most recent decision, which goes to the same point, is Langa versus Premier of Limpopo and others. It's a judgment of Justice Teron given in 2021. Reported in 2022, volume 3, BCLR at page 367, and the paragraph is at paragraph 46, where she says, thus, if a functionary purports to exercise under one act a power that act does not confer upon him or her, that exercise of power is unlawful, even if there is another act that confers such power on the functionary. In this case, the Premier published a notice in the Provincial Gazette in which he purported to remove the applicant in terms of section 13.3b of the Limpopo Act. There is no suggestion of an administrative error in the affidavits filed by the minister. When this apparent misquote in the Premier's notice was raised at the hearing of this matter, counsel for the 5th respondent attempted to argue that the Premier had exercised his power in terms of section 30 of the Limpopo Act and only had regard to section 13. Following the court's approach in Harris, it is not open to the Premier to now place reliance on section 30. So the law on this point is very clear. If a minister issues a notice quoting a certain section, if it turns out that that section does not confer the minister the power that he thought he was issuing, the notice is invalidated without more. And that is where the force of the ultra virus has been treated very dismissively in both the answering affidavit and in the heads of argument. That's where the power of the ultra virus argument comes in. So what that means is that we can then look, I've shown the court the 5 times where the minister says I took a decision, and the 3 times where the minister identifies the source of the authority he was exercising in taking a decision not to extend. So we can then look at whether or not section 31(2)b authorizes the minister not to extend the scheme or not. Now, that's the first ground of review that we have raised. So we go then to that section, section 31, subsection 2, subsection B, which is a section relied upon by the minister for this purported exercise of the power not to renew. The section says, upon application, the minister, as he or she deems fit, after consultation with the board, may, under the terms and conditions determined by him or her, so A is irrelevant. We go to B, grant a foreigner or a category of foreigners the right of permanent residence, of course, not a right to be a permanent resident, but a right equivalent to permanent residence for a specified or unspecified period when special circumstances exist which justify such a decision, provided, and that's the proviso, that the minister may we can remove 1. We just deal with 2. For good cause, withdraw such right from a foreigner or a category of foreigners. So here, there is no right that is given to the minister not to extend a dispensation similar to the dispensation granted. It's just no such provision at all. The only provision that is made by the Act is for good cause, withdraw such right from a foreigner or a category of foreigners. For good cause, withdraw such right.
What about the fact that there should be special circumstances? And I
Yes.
think that was relied upon immensely by the applicants on the previous side.
Yes.
That there was the special circumstances which led to the existence of this policy are still in existence.
Precisely. Now, so I'm going to deal with that because it goes into the substantive challenge to the decision. That the ultra-virus challenge is find the provision in the Act that authorizes the action you purported to do. And then you can look at when will that be exercised, because under 31(2)(b) sub Roman figure 2, the only power that exists is a narrower power of withdrawal. There is no power that is equivalent to the power that they have purported to exercise here. But even, and Justice Mota, I'm coming to your point now, even that power of withdrawal is a power that is linked under 31(2)(b) to special circumstances, because it says there are special circumstances to grant you, there is a proviso. So that proviso must be linked to the special circumstances and the good cause for the withdrawal. Now, point 1 we make on ultra-virus is that the sanction the minister purports to rely upon simply does not authorize the action that he took. He is acting ultra-virus. It explains, justices, with respect, the equivocation of the department about what precisely is the statutory source that they are relying upon. It explains why they have been so equivocal about not wanting to attach their decision on section 31(2)(b) and why they have been so keen to find different characterizations of the nature of the decision. Well, it is a decision not to extend, which is what is explicitly pleaded. And then in argument, well, it is a decision that confers rights, not a decision that takes away rights. It's because we have a fundamental problem that the minister has relied on a section that does not authorize him to perform the action he purported to perform. So the ultra-virus argument is, with respect, unanswerable. We then go to the second problem, which is what Justice Mota is urging me to move towards, which is, if you assume that what is in fact happening here is a withdrawal, and I've shown the court that there is no withdrawal taking place, the only way that the minister could have relied properly on section 31(2)(b) is if he could show that he is doing a withdrawal. But he is running away from saying he's doing a withdrawal. But the more he does that is the more he gets outside the ambit of the legislation that would potentially authorize him to act lawfully. And that's why we say ultra-virus, problem number 1, is outside the Act, is purported to rely on a section, he is bound to prove that that section was correctly invoked. We then go to the second problem, which is the question of rationality. So ultra-virus is the first problem. Second problem is rationality. Now, again, there is a lot of debate about what rationality means. From the early days where it was decision must be based on rhyme, reason, to now where it's generally accepted that the decision must lack arbitrariness in order to be rational. And Mr. Badlander described it as means versus ends approach. But I want to stick to arbitrariness.
Mr. Toby, if you could just hold it there, and if I could take you back to section 31(2)(b), Roman figure 2. For good cause, withdraw such right from a foreigner or a category of foreigners. should that be read as it appears to me that it could mean withdrawing a right while it still persists under a dispensation? Because there can be no withdrawal if the right or if the dispensation itself has terminated.
Yes, I see the point. In other words, if it has terminated by operation of law, can you still withdraw afterwards? Or
Indeed.
can you only withdraw during the existence of the right?
Correct.
What we can say is that it seems that it contemplates a scenario in which you withdraw during its existence. Say, I want to withdraw during its existence. Now, once it terminates by so-called operation of law, it seems that using the term withdraw in those circumstances would then be an anomaly. So that's the answer I can give to this. But Justice Malindi, the point here is this one, is this. The minister says that he has acted under 31(2)(b). The only power he has under 31(2)(b) is a power of withdrawal. And he says he has exercised the power not to extend. The question is, can he show that he has a power not to extend under 31(2)(b)? And that is why we want to take the court closely to the section. What are the powers granted to the minister? Does the power that he says he exercised exist under the statute? He could have done this, he could have withdrawn. He could have said, from date X, I'm withdrawing. But there would still be jurisdictional elements that he must satisfy, good cause being one of them, special circumstances being another. I'm going to address that now. So I think the answer to the question, so that I don't appear to avoid it, is that it seems withdrawal contemplates the duration of the right existing and does not contemplate a scenario in which the right has in any event come to an end and therefore no longer exists.
Counsel, I'm sorry, my brother.
No, I was thanking him to go back to rationality and arbitrariness.
Before he goes there, there's this confusion in my mind because, you know, we've had a number of dispensations under different eras. Let's focus now on this ZEP era. Didn't it have a time of commencement and a date of termination? Now, how do you join the two? Because they would say, for instance, it started in 2017. Are you still with me, Counsel?
Yes, I am.
Yes, it started in 2017, and it was always intended to terminate in 2021. I understand that you want to locate the termination within the act that they say they were operating under. But there's that policy decision, if you want to call it that way, to say each and every dispensation came to an end. If you look at Gigaba era, it came to an end and no one challenged it, it ended. If you look at you have these acronyms, the DZ, DSP, the D. I'm sure if you follow me those, yes. So now, what would this be? Why would this be different? Was it not also destined for termination come 2021 December?
Yes, no, that's what I'm going to deal with on rationality. But let me answer your lordship now, actually, so that I can. It's 1 minute past 1. I don't know whether the judges want to take adjournment now or come back, but let me answer the point now because it's relevant, because it's the heart of what the government says. And I've shown what the law requires them to show. What we argue about this idea of the system having automatically terminated is we say that the decision that they took, which is a decision not to extend, was itself bound by the Constitution. And if it was bound by the Constitution, that decision had to pass the threshold of rationality. But it was also bound, because it was an administrative decision, it was also bound by PAJA. The decision they took in September of 2021, decision not to extend, it was bound by the Constitution, it was bound by PAJA. So they don't get out of it by merely pointing out that there is an alternative set of facts that could have happened, because they must answer the case right now, which is they took a decision not to extend. The question is whether the decision they took not to extend passes muster under PAJA, passes muster under legality, and does not amount to an infringement of the Bill of Rights.
So are you saying you are not putting all your eggs in one basket now? Because that's what I understood you to be saying, that PAJA is applicable here because
Yes.
we're dealing with the administrative decision, and we both know that both under PAJA and principle of legality, you have rationality.
Yes.
So which one are you focusing on when you're going for rationality? Are you extending your scope to cover yourself in case we do not agree with, we are not with you on PAJA? We are also able to cover you on rationality, on principle of legality.
No, I think the pleading, in fact, does say it's a PAJA decision. It is also a legality decision. It is also an infringement of the Bill of Rights.
Okay.
So the mere fact that you find for me on PAJA does not mean you should not find for me on legality. But it may mean that regardless of what your decision is on PAJA, you still have to find for me on legality. But to answer your question directly about the termination, is on the common cause facts, a decision was taken not to extend. That decision is not free of constitutional constraints. It is subject to PAJA, subject to legality, subject to the Bill of Rights. And so the function of the court is to assess whether the decision taken in September of 2021 passes muster under those three constraints to the exercises of public power.
Yeah, in fact, you have Democratic Alliance case where they said it should be an anomaly if it's rational under PAJA and irrational under principle of legality. If it's irrational, it remains irrational throughout.
Indeed. And I think the test in any event is probably the same, except that PAJA will give us a reasonableness standard and the rationality will not give us a reasonableness standard.
Mm-hmm.
But also PAJA would give us procedural fairness, but rationality would not give us procedural fairness. Now, so that's the direct answer to the question about the termination versus the decision that is being made. So,
Sorry, can we adjourn for lunch now? Sorry, I'm not intending to sit through lunch.
no, I have no difficulty.
Okay.
I'm happy to adjourn.
Yeah. Can you indicate to the court how long will you still be out for lunch?
Another hour and a half.
Another hour and a half.
Yes.
Okay, thank you.
Thank you.
So we'll adjourn for lunch and we'll reconvene at 2 o'clock.
As the leadership pleases.
Thank you.
My lady, I'm just waiting for Judge Malindi to join the platform.
Thank you.
May it please the court. I confirm resumption of proceedings for case number 006386 of 2022. May it please the court.
Are the parties all online?
Justice Collis, yes, I am here. I think Mr. Rosenberg is here. We had discussions during the adjournment. They are not yet finalized. I wonder whether we can finalize them in the next 15 minutes. If the parties find each other, we will inform you. But if no agreement is reached, then we may just resume. I've just sent a message, Sean, to Ishmael.
Okay, we have a different challenge ourselves. You know, this matter is only set down for today's allocation. Tomorrow we've got another application to deal with. And although I also had another meeting to attend to, in respect of another matter, I've asked to be excused from that particular meeting. So we were going to restrict your argument further, Mr. Kaitobi, only to another hour. In other words, instead of another hour and a half.
No, that would have been more than adequate. In fact, 45 minutes would be adequate.
Okay, and then for Mr. Rosenberg, then to be given these 2 hours, but we would hope that he could perhaps not go beyond that time. We simply don't have the time because we would now, as a result, have to sit beyond the official court hours. We need to finalize the hearing of this application today.
All right, let me put it this way, my lady. If we can't settle, and it looks like there is a prospect of settling,
Yes.
I will not argue for more than 45 minutes to save everyone the pain.
Okay, that's fine. So we'll reconvene it in 15 minutes time then.
Yes. Thank you.
Mr. Rosenberg, do you confirm that?
Yes, thank you, Judge Collis.
Okay, thank you.
Thank you.
Judge Collis, I confirm that. Okay.
Thank you, Mr. Rosenberg. The poll, are we ready?
If you can just wait if maybe 2 minutes, Judge, just for the other judges to also be online. Judge Motta is online. Malindi, just waiting for Judge Malindi to join the platform.
Thank you.
Thank you, Malindi.
Thank you.
Malindi, then I confirm resumption of proceedings again for 006-386 of 2022.
Thank you.
Thank you, my lady, and thank you for the indulgence. Perhaps to give an update to the court, there is an attempt to settle the case, but I'm not at liberty to disclose the term, the proposed settlement at this stage. But we are unable to finalize it because neither the DG nor the minister is available to give instructions to my learned friends. We've agreed that we will press ahead with the case. If it does get settled, the court will be informed so that you are saved from the process of judgment writing. If it happens during the course of this afternoon, you will also be informed. What I propose to do is that I will spend 45 minutes more to finalize my argument, which means that I should be finished by 3:05, 3:10, thereabout. Hopefully that will give enough time to Mr. Rosenberg, and I would have taken an hour and 45 minutes if I stick to that.
Okay.
Thank you, my lady. To finalize the point I was making, Justice Motta, around the Tau judgment. In fact, the passage you had in mind is paragraph 39 of that judgment. It says, as further assistance, a number of pointers can be extracted from previous decisions, which are helpful in assessing the nature of a particular power. First, it may be useful to consider the source of the power. Where a power, and that's the point, flows directly from the Constitution, this could indicate that it is executive rather than administrative in nature, as administrative powers are ordinarily sourced in legislation. So that's the point I was driving to say that whatever the government says about the fact that they took into account policy consideration, the fact of the matter is that when they executed that decision, they acted under legislation. And so even if you are trying to characterize the decision on a broad level, you ultimately come to the conclusion that it is the exercise of an administrative discretion. And what also shows this, I think Mr. Butler made this point, is that the government did have a discretion about what to do when the ZEP lapsed. It was not bound to act in a particular way. It could elect to do nothing. It could elect to extend the program, or it could elect not to extend the program. It actively exercised the third of the three options, which was a decision not to extend. So it was engaged in the exercise of its discretion, which it believed rightly that it had under section 31(2)(b). So they were not absent-minded, they were actively thinking what to do. And that is why it's impossible to argue that they were not constrained by PAJA or constrained by legality or constrained by the Bill of Rights. If I then move to the second ground of review, I've already debated the ultra-virus ground of review. If I go to the second ground of review, that second ground of review is what we have described as arbitrariness, that the decision lacks rationality, whether it is rationality through the prism of PAJA or rationality through the prism of the principle of legality. Again, we have to go back to the basics about this principle. What is the minimum threshold that they had to meet? We listened carefully to Mr. Jamie when he articulated their position on rationality, which is the goal that they had in mind was the goal of terminating the ZEP policy. The question was whether or not they could terminate it in the way that they did. And he's then concluded that it was therefore rational. But with respect, we disagree with the formulation. That's the problem with is the formulation, because the termination was in fact the mechanism. It was not the goal that was designed by the department. The goal that was designed by the department is clear from the evidence. The goal was how should South Africa deal with the problem of migration from Zimbabwe arising from the decline in the economic and political situation in that country. That was the goal, is how should South Africa respond to that? The way, which is the measure that they took, was we are not going to do asylum applications because we don't have the capacity. We are not going to do all of the visa applications because many people will not qualify. The mechanism would be the ZEP program. So that is how the proper means and end analysis should work. That's the goal they identified, is how do we deal with the problem of downward migration from Zimbabwe in the light of the collapse of the political and economic situation in that country. We will deal with it through the ZEP program. You don't have to speculate on this because it's plain on the papers. And we have dealt with it in a founding affidavit from 001 to 00134 to 00138. So when the scheme was introduced in April of 2009, which you will find in paragraph 71 of the founding affidavit. Again, the department doesn't dispute this. In fact, in its heads of argument, it says the facts are common cause. The problem is identified here. In April 2009, South Africa implemented the DZ project to regularize the large numbers of Zimbabwean nationals residing in South Africa irregularly. The extraordinarily high number of applications under the Refugees Act that were lodged by Zimbabwean nationals who had fled to South Africa exceeded the capacity of the Department of Home Affairs to properly consider and, where appropriate, issue asylum and refugee permits. This raised the need for a special response to the undocumented Zimbabwean migrants in South Africa to reduce the severe pressure on the South African asylum and refugee system. Now, in paragraph 77, which is at 001/35, it is stated in the speech, which is now explaining the Minister of Home Affairs in South Africa. The minister recognized that the DZP regime was a significant gesture of support and solidarity with our neighboring country of Zimbabwe in response to the large number of Zimbabweans residing illegally in South Africa due to political and economic instability there. Now, the reason we mentioned that the goal was how should South Africa respond to the economic and political crisis in Zimbabwe. It responded through the ZEP program. That is not to say, and we've heard our learned friends make the point in the HSF case, that does not mean that South Africa should provide economic and political solutions to Zimbabwe. And it does not mean that the holders of ZEPs should be in South Africa until there is absolute certainty that Zimbabwe is back to economic prosperity. What it means at the minimum is that if South Africa wishes to terminate the ZEP scheme, it must at least demonstrate a connection between the decision to terminate and the improvement in the economic and political situation in Zimbabwe. And it must do so on an objective basis. That's the minimum threshold, that if you want to terminate as you claim to be entitled to under the legislation, at a minimum, you must demonstrate that there is a connection between your decision to terminate or the decision not to extend with the economic and political situation in Zimbabwe. And you should do so not on a whimsical subjective basis, you should do so on an objective basis. If you adopted that approach, it would qualify potentially as good cause under the Act, it would qualify as rational under the principle of legality, and it may qualify as reasonable under PAJA. What you are prohibited from doing is to combine an assemblage of random facts which have no connection to why the ZEP was instituted in the first place, and use those random factors as justifications to terminate it. Otherwise, that is arbitrary. This is precisely what has happened here. Let me spend another 10 minutes on the reasons themselves, because this has also tended to be elided in the argument. You will find these reasons at 003/97. The document itself starts at 003/96. So to avoid arbitrariness, at a minimum, you must show a sufficient connection between the decision to terminate and the political and economic situation in Zimbabwe. Why? Because this was the basis on which the ZEP program was introduced in the first place. And why? Because the Act says that there must be special circumstances to relax its operative provisions. So what do they say are their reasons for the termination, and do those reasons bear a sufficient connection to the reasons for the introduction of the program in the first place? So reason number one is at paragraph 7.1, which is at 003/97. It says the decision of the minister was taken inter alia due to the following reasons. So again, we don't have to speculate. The minister has tied his colors to one mast. Says the exemptions granted to the Zimbabwean nationals was and has always been a temporary measure. And then look at what follows: pending improvement of the economic situation in Zimbabwe. So not only in 2009 when they introduced the program, or in 2014 when Minister Zolimkhize reintroduced or extended the program, even as late as 2022, they still identified the rationale of the introduction of the program as pending the improvement of the economic situation in Zimbabwe. Look at what they say thereafter, which is where the decision becomes completely arbitrary. In 2008, approximately 200,000 people arrived in South Africa seeking asylum, the majority of whom were Zimbabwean nationals. Again, in 2009, another 207,000 people arrived seeking asylum. Similarly, the majority were Zimbabweans. The extensive nature of the asylum applications to Zimbabwean nationals overwhelmed the administrative capacity of the department's asylum seeker program, and resources were overstretched. This status has been exacerbated in prevailing years with an accumulation of appeals within the statutory bodies responsible for rejected or failed asylum applications. Again, no connection to the situation in Zimbabwe, simply talking about the administrative infrastructure in the department that is collapsing under the weight of these applications. 7.2, the Department of Home Affairs has encountered limited capacity to respond to such capacity constraint by virtue of its constrained budget. Yes, that is maybe so, but again, it has no relationship whatsoever to the reasons why the program was introduced. And then they talk about COVID, they talk about the reduction in the budget, they ultimately talk about their decision to prioritize their budget. And then they say, as matters stand, the Department of Home Affairs is unable to employ more staff in the immigration services. Therefore, it had to prioritize the budget and allocate more resources to civic services, which in essence deals with the rights of South African citizens. Now, we just pause here. We have explored now the two reasons they've given. Firstly, they say we had no capacity to address the many asylum applications. Secondly, we had no money to do it. How is that an explanation for terminating the program? Because the termination of the program means that many of those applicants must now apply for the other types of visas. But they have no money and they have no people to manage those visas because there has been a reduction in the money that is available and a reduction in the people. But they are not addressing the fundamental problem, which is what did South Africa do in order to satisfy itself about the improved economic and political situation in Zimbabwe? We then look at the third reason, which is in 7.3. According to Statistics South Africa, quarterly labor force, South Africa's unemployment rate increased by 1.8%, bringing the overall rate to 34%. This is the largest recorded since the start of the QLFS in 2008. Now they're saying there's a lot of unemployment in South Africa, but that again is unrelated to why they introduced the ZEP program in the first place, unrelated to why it should be terminated in the first place. And then the closest we get is paragraph 7.4, which is the DHA came to realize that some of the Zimbabwean exemption holders were violating the conditions, in that about 1,900 were somehow able to apply for waivers in terms of the Immigration Act. Their applications were rejected. So in this passage, you are finding an internal contradiction, because the department says there are ZEP holders that are breaking the conditions of the ZEP. We have caught them out and we have rejected their applications for waivers. That again is an arbitrary factor in relation to the termination of the program as a whole. If it was true that there were ZEP holders that were breaking the law, their ZEPs must be withdrawn and those particular individuals must be deported. What you cannot do, you cannot take, even if you took this entire 1,900, which you have identified, you cannot use that 1,900 as a justification to guillotine 178,000 people. It's using a sledgehammer to break a nut. You are taking a very small sample and then punishing many, many law-abiding people for sins that have been committed by a very, very tiny minority. So the four reasons that they have given are a constellation or an assemblage of random facts that do not bear any relation to the reasons why the program was introduced in the first place. Those are the reasons they gave at the time. And the court knows the law is that you are bound to the reasons that you gave. You may not give new reasons at a later stage. What we also know is that in the answering affidavit, they have introduced reason number 5. And that reason number 5 is in Annexure AA13, which is at page 003114. Now, this is the speech given by the Honorable Frederick M.M. Shava, who is a Minister of Foreign Affairs in Zimbabwe, which he gave on the 10th of August, 2022. They say that speech shows that Zimbabwe is ready to accept persons whose status has terminated. But there is a problem. The problem number 1 is that that speech is dated the 10th of August, 2022. It is impossible that the minister took that into account when he decided to terminate the program in September of 2021. The second problem, of course, is that the speech is not evidence of any improved economic and political situation in Zimbabwe. The mere fact that the Zimbabwean government is ready to welcome its nationals when the ZEP ends does not say anything about the objective factors. So on the reasons given, you have no rationality, you have no reasonableness, you have no good cause. What the facts do show, which is what this court can take into account, and I heard Mr. James say that the question of the political and economic situation in Zimbabwe is outside of judicial scrutiny because it is a matter of political judgment. It's quite frankly unclear why that is so, because it is a question of fact whether or not the precondition for granting these ZEPs has changed to justify rationally its termination. And the government must produce the evidence, and the evidence must be assessed on an objective basis. It cannot be up to the opinion, the whim of the government to say, I think the situation in Zimbabwe has improved, and therefore everyone in South Africa must be told to believe, even if the evidence shows the contrary. What is actually happening in Zimbabwe is much more depressing than what the Minister of Foreign Affairs would have us believe. And we are not making a political point when we make that. We're making a pure factual point. The documents that have been attached in the founding affidavit really do point a depressing picture of what the state of affairs in Zimbabwe is. And I want to just show the court what the real situation is. And this is referred to in 001/55 in the founding affidavit from paragraph 154, which is the report of an organization known as BTI. I'm trying to see its full name. The actual report is at FA9. What it shows from paragraph 154.1 of the founding affidavit is that under President Mnangagwa, the challenges that were present under President Mugabe have in fact remained unaddressed, in some instances have intensified. They show that the economic crisis in Zimbabwe, characterized by high prices, cash shortages, and a huge debt overhang, continue. They show that the economic decline has resulted in a severe humanitarian crisis in which over 7 million Zimbabweans are in need of food. By the end of 2020, they were in need of food aid, they needed food handouts. They also show that in the last 2 years, there has also been a shrinkage of the democratic space and the failure to uphold the rule of law. In January 2019, there was a crackdown by the state security apparatus, which responded with disproportionate force to protests over poor living conditions, which was followed by 2 years of increased repression against opposition members, activists, journalists, and other actors. And they show that there were cases of abduction, torture, sexual abuse, and subsequent arrests of 3 female opposition leaders in 2020. One example is the prominent journalist Hopewell Chinono, who had exposed government corruption. And they show that there is a systematic repression, which has also been made worse by an increasingly partisan judiciary, which has led to lengthy pretrial detentions of opposition members, activists, and journalists. And these arrests have led to further polarization of the political domain and a continued stalemate between ZANU-PF and MDC, which also has negatively affected the prospects for rational change. And if you look at the report by Amnesty International, published only in 2021, which says that the human rights situation has continued to deteriorate in Zimbabwe, and the government is demonstrating hostility to human rights defenders, protesters, political activists, and journalists. They were harassed, arrested, prosecuted, subjected to prolonged pretrial detention. And the state has weaponized COVID-19 lockdowns to restrict political activity. Security forces carried out unlawful killings. Public hospitals remained underfunded. There is poor healthcare infrastructure, and that has put women and girls' health at risk. And many people were at risk of becoming stateless. Not only is it the BTI and the Amnesty International, the Human Rights Watch has also stated in their 2021 World Report that Zimbabwe's human rights situation has continued to decline in 2020 under Emmerson Mnangagwa's presidency. There had been unidentified assailants suspecting to be state security agents, abducted and tortured more than 70 critics of the government during 2020. Security forces have also continued to commit arbitrary arrests, violent assaults, abductions, torture, and other abuses against opposition politicians, dissidents, and activists. So in summary, contrary to the very vague assurances by the South African government, what we have is a truly depressing situation of what is happening economically, politically, and for the rule of law in Zimbabwe. So, contrary to the assurances given to the Minister of Foreign Affairs in Zimbabwe, Mr. Shava, what the facts show that have not been conducted by us, they've been conducted by 3 international credible human rights organizations. They've shown that actually things are getting worse in Zimbabwe. They're not getting better. The minister has attached 2 other documents to try and shore up this idea that things are getting better. The first document you will find at Annexure AA14 003/122, and then you will find the second one, which is the report of Amnesty International, but it's a 2010 report attached at 003/129. But even if you read the first report, what it does say is that we no longer have a 43% unemployment problem, but we have a 41% unemployment problem, which shows that even those improvements are actually minuscule. And in fact, in many respects, it confirms when you look at outlook, you look at the key conditions and challenges, you look at recent developments, it confirms in substance that on the 3 matrix that informed the decision of the government, which is the economy, the political space, and the legal space, that on all of those 3, in fact, what seems to have been positioned in 2009 has simply not, and in fact, in the last 2 years, the levels of repression seem to have been getting worse, and the levels of poverty are getting worse, and the levels of the economic migration continue unabated. So what then, if we just took a step back, what then justifies this decision? What justifies this decision? It's a completely arbitrary decision, which is not informed by any objective facts. And if the government does have a basis to justify the decision, sadly, it has not been able to plead it. There are some references to unemployment in South Africa, but that again has nothing to do with why the ZTP was introduced, and therefore can have nothing to do with why it was taken down. There are some references to the collapse of the South African Home Affairs Office to manage the asylum applications. That collapse will not be improved by terminating the program. In fact, it will be made worse by terminating the program. So when you actually assess in detail, line by line, what they say, it's no wonder when you were treated to the argument by the department, what you had were broad general statements, never the actual facts on the ground, and never the actual justification for the decision. So you have the proper situation in which there is, in fact, arbitrariness in the decision that has been taken by the government. And there is no connection to why the scheme was introduced in the first place. And there is evidence that shows the contrary. And none of that evidence was in fact taken into account by the government, because we know this from the 4 reasons that they have given, that the true political, economic, and legal situation in Zimbabwe was simply not taken into account. Now, when we say that, we don't say the court must second guess or judge for itself. We simply say you must do what the Constitutional Court said should be done in Mazibuko at paragraph 161, which is when the government says it wishes to take a decision based on policy, it must at least show what research it has done to arrive at a policy. What alternatives has it considered? What consultations has it conducted? And with whom? And why did it choose policy X over policy Y? Here, we have none of those. We have none of the legislative constitutional checks in order to assail or confirm the validity or the rationality of the policy option that has been taken. It is simply asserted, and the judges are then expected to buy it without interrogating it. So we say on point 2 that we have a classic arbitrary decision, and it is in conflict. It's a situation where the decision is in conflict with the true facts. So that means, in addition to what you heard on Tuesday, we have a problem on ultra-virus. We have a problem on rationality. And the points I've just addressed now go to reasonableness, they go to rationality, they also go to whether or not there is good cause, which the court must itself be satisfied that good cause either exists or doesn't exist. But they show that the decision simply cannot be sustained. Mr. Badlander has dealt at length with procedural fairness, and I don't want to waste time on procedural fairness. He has also dealt at length with procedural rationality. I don't want to deal with that. What remains for me is to address then the other requirements for interim relief, having shown that on the prima facie side, the case is actually extremely strong. But before one does that, one must look at the remedy that we ask for and why that remedy is crucial to this case. And it's probably more important right now, whilst your ladyship and your lordships are considering what to do with the HSF application. This relief is in page 001/3 of the Magadziri application. The first paragraph, 1.1, says that pending the outcome of Part B in this application, we want an interdict to restrain, interdict from arresting, issuing an order of deportation for the purposes of Section 34 of the Immigration Act for any reason related to them or for not having any valid exemption certificate in his or her passport. Right now, the holders of the ZEPs are protected from the operation of Section 34. Now, when you look at the government's approach in this, and you will find the passages when they deal with reasonable apprehension of harm. They basically say, look, and you will find this at 003/19. 003/17. So in paragraph 50, they say it is clear from the directives that no ZEP holder faces deportation or arrest. In fact, no ZEP holder has been arrested for deportation purposes. ZEP holders continue to travel in and out of the country freely. And then when they deal with Section 34, which is in paragraph 52, they say Section 34(1) of the Immigration Act confers a discretion on an immigration official whether or not to effect an arrest or detention of an illegal foreigner. There is no obligation to do so, even in cases where there are no directives. Now, when you actually look at Section 34, subsection 1, what you find there, firstly, illegal foreigners are dealt with in Section 32(1). Any illegal foreigner shall depart unless authorized by the department to remain in the Republic, pending his or her application for a status. So you have a duty to leave the country unless authorized by the department. And then paragraph 32, subsection 2, any illegal foreigner shall be deported, which is clear. It says shall be deported, and you have no right to be in the country. So it's called comfort to say we may not deport you, when in fact the statute says you shall be deported, and when the statute says you have no right to remain in the country. So the reality is that you don't have a proper defense to the risk that faces the ZEP holders come the 1st of July, which is why paragraph 1.1 is crucial. Paragraph 1.2, no holder of ZEP may be dealt with in terms of Section 29, 30, and 32 of the Immigration Act solely for the reasons that they are a holder of the ZEP. Now, again, those are the provisions that would have taken away the ZEP, and then what would happen is that they would be rendered illegal foreigners. And paragraph 1.3, the holder of the ZEP may be allowed to enter into or depart from the Republic in terms of Section 9 of the Act, read together with the immigration regulations, provided that he or she complies with all other requirements for entry into and departure from the Republic, save for the reasons of not having a valid permit indicated in his or her passport. So it's a modest relief, simply intended to protect the ZEP holders from deportation, the consequences of illegality in the country, and possible arrest. And it will not last beyond the final determination of the case. And if we lose the case in Part B, of course, the consequences of the statute must operate. But the question is, why should they operate now where there is a bona fide challenge to the validity of the decision by the department? Why? What is the harm that the government will experience if it allowed people to be here for a little longer than it intends, especially in circumstances where it is at least strongly arguable that they may win the case? Because ultimately what you are left with, and I want to address this squarely under irreparable harm, what you are left with under irreparable harm is this scenario. We are either going to win the case in Part B or lose it. If we win the case, but we have been deported, the very consequence that we are fearing would have occurred. And the very harm that we are complaining about would have come and gone. And the success in Part B would be illusory. Because if you are a mother and you don't want your child to go back with you to Zimbabwe because they're at school in South Africa, that will split from the mother, from the child. And if you had a job, you don't want to lose your job because you are the holder of a ZEP, you would have lost that job. If you had a business, you would have had to close down the business. So you have to ask yourself, why is the department so hell-bent in insisting that its decision must come into operation after the 30th of June? Why is it not willing to allow people to stay on a temporary basis while the judicial process runs its course? The court will remember the judgment, which we have cited, the judgment of Piccoli versus the president. In the case where Mr. Piccoli was facing a suspension, and in the course of that suspension, the department wanted to terminate his employment contract. And when the case came before the High Court, Judge du Plessis said, one of the reasons why you grant an interim interdict is to safeguard the rule of law. Because if Mr. Piccoli wins his case against the president's decision, but in the meantime he has lost his job, that will destroy the credibility of the legal system because he will get an empty order. So we face a scenario in which people are in fact going to get an empty order. We can then explore the balance of convenience argument, specifically because what the government says is, don't worry. Why? We have never exercised our discretion in ways that are against your clients. 2, your clients are entitled to apply for the other forms of visas. What are these other forms? We know there are 3 primary forms of visas: study, work, and the business visa. But on the 1st of July, everyone will become illegal. If you want to apply for these visas, go to Zimbabwe, apply in Zimbabwe into South Africa, unless you can apply for an asylum. But we know on their own facts that the asylum system is not working. The government says, we've reduced the staff, we've reduced the budget. We are overwhelmed by the asylum applications. It says so in paragraph 7.2 of the letter that it sent out to Scalabrini. It says the asylum system is just not working. And we know that there is no evidence of any improvement of the asylum system. And we know that one of the factors they took into account when they introduced the ZEP program was that the asylum system was not working. And in the intervening 14 years since they introduced the ZEP, the asylum system has not got better, it's got worse. So to say then to my clients, they must apply for asylum status if they have reasons of political persecution, they must apply for a business visa, they must apply for the other types of visas, in a system that you admit is dysfunctional, is not an answer. So when you look now at the third requirement for interim relief, which is balance of convenience, it's plain that the balance of convenience favors the granting of the interim relief application. And there is no basis why the government wants the decision to be enforced immediately. There is no reason why it cannot wait. Then you have the final point, which is, well, you have alternative remedies. What are these alternative remedies other than going to court? We can't write to the minister. The minister has made his position clear. We can't apply at Home Affairs for these other types of visas because both of those are discretionary. Secondly, most of my clients, they say on oath that they simply won't qualify for those. And the problem we still face is that the day of the guillotine is the 1st of July, it's fast approaching. So we have a problem of a massive outflow of tens of thousands of people in one day. What happened in Uganda with the expulsion of Indians under Idi Amin's regime will appear to be a picnic compared to the catastrophe that is coming on the 1st of July. And quite apart from the fact that it's an impractical thing, how is South Africa going to expel so many people on the 1st of July? How is this going to happen practically? And so it's completely perverse for the minister to refuse to extend the benefits until the judges have decided what to do with this, whether we are right or whether the department is wrong. It's a truly perverse position to adopt, that you want your decision to be enforced, even though you know the human tragedy that will underpin any massive migration of people. And this is not voluntary migration. This is going to be forced migration because it has to be executed by law. So, and if the government wanted to undertake that it will not forcefully deport people, it could have undertaken, it refuses to undertake that. So when it comes to these alternatives that we have, these are not real alternatives, they are illusory alternatives. The only realistic alternative that my clients have is to ask the court to grant them a temporary stay of execution. They may win their case, they may lose their case. If they lose their case eventually, then their legal options have run out. But until they've exhausted these legal options, they are entitled to the extension by way of a judicial decree. You then have this very strange argument, which was repeated this morning, that there is a connection between this case and the HSF case. Now, let me just answer this for the second time. It does not matter what happens in the HSF application. It doesn't matter for the purposes of the interim relief, because the HSF is asking for final relief. They're asking for final relief. If final relief is granted in that case and an appeal is held, even though there is an interdictory relief that regulates the status quo, the fact of the matter is that under Section 17 and 18 of the Superior Courts Act, all of that will be suspended. And once it is suspended, we are back to where we are right now, which is my clients are vulnerable to deportations, mass arrests. If they are not to be deported, and most of them will not want to be deported forcefully, they have to self-deport. But again, that is the humanitarian crisis that we are trying to avoid by coming to court today. So regardless of what your ladyship and your lordships think about the prospects of the HSF case, it cannot be a basis on which you do not grant interim relief. And we have explored here the perverse attitude of the government, in which it puts us under pressure in our case on the basis that we should all be asking for asking for final relief. And when we do ask for final relief, it then opposes it. And then in the course of the argument against interim relief, it says, why don't you ask for final relief? You will not countenance that approach because the litigation is being pursued by the government. The government is not just any ordinary litigant. It has a duty to do right. It has a duty to do that rightly. It has been repeated in the public protector case versus South African Reserve Bank that when you are dealing with an organ of state, there is an expectation that the way they litigate must be in good faith. This is not good faith litigation where you tell a party you are better off with a final order. When they ask for a final order, you oppose them. And when you try to ask for interim relief, you say, why didn't you ask for a final order? That is not befitting of litigation against an organ of state. Finally, we ask for costs. We have 3 advocates. The case is sufficiently large. The government also has 2 senior counsel, 2 junior counsel. Everybody thinks that this is a case worthy of more than 2 counsel. So we would ask, if we are successful in Part A, for a cost order inclusive of 3 counsel. Thank you, my lady, and thank you, my lords. I think I still saved 2 minutes.
Right. Do you have any questions, Judge Malinde?
None from me, my sister.
Thank you. Judge Martin?
No, none.
Thank you, Advocate Nkaikobi.
Thank you.
Advocate Rosenberg, are you ready?
Yes, thank you, Justice Collis.
All right. We are going to give you 2 hours, not more than that, please, if you can ensure that you are done within the time frame. I'm not going to do that.
Thank you, Justice Collis.
Thank you.
May I start off, Justices, by emphasizing that there are certain clear and undisputed facts which should guide the approach to this particular problem that is faced. Facts which relate to the decision, the impugned decision, because once one has clarity on the impugned decision, that in turn provides a pathway to determining who is affected by that decision, questions of the requirements of procedural fairness, procedural rationality, which may be implicated in that decision. And that's why it's so unfortunate that throughout this case, there has been a feature that the parties have referred without sufficient rigor to various characterizations of the decision in question. We know that the decision in question was a decision that was made by the Minister on the 20th of September 2022 on the basis of a reasoned recommendation presented to the Minister by the Director General. And the court was taken to that, and some time was spent in analyzing that document, which ultimately is the best evidence, or it is the documents evidencing the decision. And taken together with that decision, one then sees the Directive 1 of 2021. In these papers, it's at AA2, but the court will be well familiar with Directive 1 of 2021, which implemented that decision. And along the way, we have press releases, press statements, letters to various instances, and in fact passages in affidavits which refer to the decision not uncommonly in conflicting or contradictory terms. And it's in that context that I would repeat my point that made earlier this morning, that this court ultimately is the only party that is going to be responsible for determining what, on the objective evidence available, the decision was and what the character of it was. No matter what the DG says, in fact, it may be no matter what the minister might have said at any time. Ultimately, the court will look at the minister's or the DG's recommendation of 20 September 2021, the minister's endorsement of certain recommendation, and thereafter at Directive 1 of 2021, and it will look at that in context. And what is the context that the court will bear in mind? There are two crucial aspects of the context. One is the statute, the permit regime that has been in place, and two, the statutory regime, and in particular the provisions of Section 31(2) of the Immigration Act. Because it's common ground, certainly the HSF COMSA applicants, and in fact the applicant in this matter, contend that the decision in question was taken in the course of the exercise of powers under Section 31(2)(b) of the Act. And certainly the minister himself, when describing in Directive 1 and in his press statements, made it clear that he acted in terms of Section 31(2)(b) of the Act. Now, you heard argument yesterday and the day yesterday by counsel on behalf of the minister in relation to the difficult issue of the proper characterization of any decision that the minister may have taken antecedent to the actual issuing of permits and the like, an antecedent decision about whether or not to establish a permit regime, whether or not to continue with the permit regime, and what the nature of that decision was. When it may be said it wasn't a decision of a conventional administrative character, and it was possibly, or contended, it was a decision which doesn't necessarily fit into Section 31(2)(b). I'm not going to repeat those arguments in relation to the proper character of that decision or that element of the decision. I'm going to focus rather on the case through the lens of the applicant in this matter and the applicants in the COMSA HSF matter, who both contend and impugn a decision which was taken in terms of Section 32(1)(b), and it's a decision which is described in different ways. And as far as the HSF COMSA application is concerned, you will be aware that the contention in that case is that the decision that is sought to be set aside was described as a decision to terminate the Zimbabwe exemption permit and to grant a limited extension of only 12 months and to refuse further extensions. That's how the decision is described. A decision to terminate the permit, a decision to grant an extension of the permit for 12 months, and a decision to refuse further extensions. One will immediately be struck by the fact that that is an unwieldy type of decision, and it's a description which indicates perhaps a difficulty in conceptualizing the true nature of the decision. So that's why one has the breadth of that description. Contrast that with the decision which the applicant in this matter, in its draft order for final relief and in its notice of motion, captures, and that is a decision not to extend the exemptions granted to Zimbabwean nationals under section 31(2)(b). So these conflicting and in a sense unwieldy descriptions of the decision portray the difficulty, or indicate the difficulty that will be faced by this court in actually determining the legal nature of the decision, what we have referred to as the operative decision in this matter. And in coming to that conclusion, we would say that you will reach that or conduct that evaluation within the context of the Act, 31(2) of the Act, and within the context of the exemption regimes that have applied from time to time. And we have, or the court has heard repeatedly what the history and sequence of these regimes are. But can I just confirm that in each case, you have a decision by the responsible minister to establish or put in place a particular regime within the context of which action will be taken in terms of section 31(2)(b) for the issue of exemption permits. And the DZP regime, as we know, lasted over the period 31 December 2010 to 31 December 2014. It was for a 4-year period, and permits that were issued pursuant to that regime terminated, as did that regime, on the 31st of December 2014. The Zimbabwe special permit followed, and that was the regime that was effective for the period 31 December 2014 to 31 December 2017. It was that regime was announced in August 2014. Parties who wish to take advantage of that offer, if one can describe it as that, had to apply for permits within the remaining months of that year, and those permits granted in terms of section 31(2)(b) were effective up until 31 December 2017. That was then followed, as we know, by the ZEP regime. Again, it is a proposal or an offer or an invitation, and during the period of that regime, applications are made and permits are granted, and they are, each and every one of those, some 178,000 permits, is due to terminate on the 31st of December 2021. So against that backdrop, if one then has regard to the provisions of the Act, and in particular section 31, Section 31, bear with me, Section 31(2) B provides for the grant of the permit for a specified or unspecified period, and 31(2)B Roman 2 provides for, on good cause, a withdrawal by the minister of the rights, or the withdrawal of the permit. And 31(2)D provides for the minister, on good cause, to withdraw the entire exemption granted by him in terms of the section. We know as a fact that at no stage prior to the lapsing or termination of the 178,000 permits on 31 December 2021, was there any intention or any action taken or any consideration given to withdrawing any rights attached to those permits, or to withdrawing the permits themselves? So there was no question of any action to terminate, and it would be a premature termination before their lapsing. There's no question of any intention to withdraw any rights or to terminate the permits. So when there is, in other contexts, references to a decision to terminate the permits, in the first instance, one must recognize that as being perhaps loose talk, or talk that is not anchored in the provisions in this context of Section 31(2). Because the first proposition I want to make, and must be the first stake to drive into the ground in order to navigate round what is a difficult problem, is to accept with respect that there was no termination by any act of the minister of the ZEPs. That's the first proposition. There was no power exercised in terms of Section 31(2), and everybody's agreed that the powers that were exercised that were Section 31(2) powers. The second proposition, the second stake that should be driven into the ground, is it is common cause that on the 20th of September, the minister extended the ZEPs by 1 year. That, with respect, is the first and in fact the only exercise in the context of this matter of a Section 31(2)B power. And I would urge the court, both now and when considering the matter in the in future, to bear that in mind. There was no extension, there was no termination of a ZEP permit, not one single permit of the 178,000 permits was terminated. 2, each of those permits was extended. So when there's talk of decisions to a decision, and we know it's only the decision of 20 September that has to be construed, when there is talk of termination and talk of a decision not to extend, it must be seen within that context.
But is the net result not going to be, come 30 June 2023, the regime will come to an end? Is that not the net effect of what you are saying?
Yes.
And the relief that the applicants are seeking here, in terms of Part A, is to afford them protection beyond that period. In other words, come 1st of July onwards.
Yes, I accept that. And I'm going to get on to the need for interim relief. But what I seek to emphasize is the confusing and misleading characterization from the get-go of the decisions that have been taken, or the decision. And I believe that it is very important that in determining what flows from and what is implicated by the decision, that the court, as I'm sure it will, have a clear-eyed view of what decision was taken and what decision couldn't possibly have been taken. So it's in that context that I submit that the minister on the 20th of September, when he was considering options that were placed before him, one of those options could have been to extend the permits by 36 months, 3 years. It could have been to extend the permits by 48 months, 4 years. It could have been that that same result of extending the permits by 48 months could more elegantly or more efficiently administratively, and that's a policy decision, have been arrived at by or through the means of a ZEP Mark II scheme, setting in place a fresh exemption regime. But those are just those would be means to an end, whether it be through ZEP Mark II or through extending the current exemption permits by 48 months, the same result would have been arrived at. What the minister was faced with on the 20th of September was a decision in the context of the ZEP permits shortly to lapse, was faced really with options as to whether he would extend them at all, and if so, for how long. That's the essential decision that was in front of the minister. And in that regard,
I'm a bit confused, with your permission, my sister. If I'm not mistaken, yesterday we heard that this decision to terminate was final, and in fact, the 12 months was implementation. Even the 6 months was implementation. It was not an extension. So are you saying the minister extended the ZEP?
Justice Mota, I think that that's common ground. HSF itself, in its notice, its draft order, refers to the decision only to extend for 12 months. I don't think that there's any room to dispute the fact that what has happened in law is a power was exercised in terms of section 31(2)(b) to extend the lifespan of the ZEP permits for 12 months beyond 31 December. That was the legal character of what was done, no matter how it's described, whether it's described as being appending a condition or granting a period of grace. The descriptions shouldn't detract from the legal character of what was done. And nobody disputes that the legal act which was carried out was a section 31(2)(b) 12-month extension.
Okay.
And similarly, nobody disputes that the legal act that was carried out in 2022 was again, in terms of section 31(2)(b), a further 6-month extension. So on the ODECAR principle, the administrative acts which have been carried out and which stand until set aside are effectively 2 acts. The extension of September 2021 and for 12 months, and the extension of September 2022 for a further 6 months. Those are the 2 administrative acts which stand. Now, I'm making the point that in the context of those acts, I will remind you, there's been no termination. There could have been no termination other than by effluxion of time on the 31st of December, but the acts of the minister prevented termination taking place because they were acts of extension. And I'm making the point that when the minister was behind his desk and was gazing at the recommendation of his Director General on the 20th of September, aware of a looming termination or lapsing of 178,000 permits, and aware quite clearly of the dislocation that would necessarily be involved, had to make a decision. And what he was deciding on was the length of the extension. And that extension could have been 1 year, it could have been 2 years, 3 years, or 4 years. Had it been 4 years, for example, there would not have been any complaint, litigation, or steps taken by any of these applicants had there been a 4-year extension. And whether that extension took place through a section 31(2)(b) decision, or whether that extension, and I put that in parentheses, whether that extension took place through 31(2)(b), or the minister devised a ZEP Mark II, in terms of which fresh applications for permits were made, is neither here nor there with great respect. There would have been no objection, there would have been no litigation, there would have been no pushback had the minister extended by 48 months. I venture to say there would have been no pushback had the minister extended by 36 months. There has been pushback, or there was pushback, at a 12-month extension, but the response to that has been itself interesting. The response has been not as it ought to have been. 12 months is an unreasonably short period. 12 months doesn't cater for the kind of dislocation. We would submit it should be 24, 36, or 48 months. Essentially, the response has been along the lines that the minister has irrationally, unlawfully terminated the scheme. That's the HSF's case. With great respect, nothing of the sort has happened. Equally, the applicant in this case also wavers between its formulation, depending on what suits it, of the decision, because we know that in the notice of motion, this applicant cast the decision as a decision not to extend. We know that in the founding affidavit where it sets out its first ground, and I can refer you perhaps particularly to paragraph 149 of the founding affidavit, it talks to, as did counsel for the applicant, it talks to a termination without good cause. And I've made the point that both of those formulations are misconceived, but they are adopted for particular reasons. It's not possible to say that there's been a termination of ZEP2.
Can you please give us the case line reference?
The case line reference, as far as this applicant is concerned, if I could refer you to paragraph, case line reference 001-55.
Thank you.
And there the case is made out as the first ground of review.
But this is under Part B.
Under Part B relates to, they say in terms in paragraph 149, the first grounds of review relates to the powers of the minister to withdraw the rights or exemptions that have been granted. And you heard from counsel under his ultra vires argument that was presented to you, that given that the minister was exercising powers in terms of 31(2)(b), ultra vires argument landed according to counsel, because that could only be done on demonstration of good cause. But I've made the point that the entire argument is misconceived. There's never any question about terminating or withdrawing the ZEP permits. The notice of motion, however, takes a different tack from how the ground is articulated, and the notice of motion contends that, in fact, the decision that falls to be set aside is a decision not to extend. And I've referred the court also to the draft order in that score. And I've pointed out that the decision in question cannot be construed as a decision not to extend, because the one thing that the decision did do was to extend first by 12 months and then 18 months. And with great respect, it cannot be construed as a decision not to extend. So in our submission, both ZIF, this applicant, with its formulation of a decision not to extend or a decision to terminate without good cause, and the HSF applicants in their formulation that there was a termination, but then paradoxically also an extension, because that's bound up in their cumbersome description of the decision. So having made that submission, this court must conclude, with great respect, or will conclude in our submission on careful reflection, that on the 20th of December, the minister was faced with a choice, effectively, on for how long he was going to extend the ZEP regime. And that meant what extensions he was going to grant to the permits. But for granting those extensions, ZEP permit holders would have been in a situation where they would have been obliged on termination of the permits to act according to the provisions of the immigration law, which would have required them to return, and whatever rights that they had, including rights of freedom of movement, children's rights, rights to dignity, and associated rights, are rights which all derive from and were implicated by, and in fact limited by, the legislative scheme and the permit that was issued in terms of that legislative scheme. And at no stage was either the legislative scheme or the permit granting and at the same time circumscribing the rights has that ever been attacked. So it's in that context on what we say is a proper characterization of the operative decision that was made. And that's why in the papers, the minister may refer to the fact, as he did, or the DG may refer to the fact that the minister decided to terminate the ZEP. That means nothing else in the context of the decision. When the minister was faced with that decision, he chose not to grant any other extension other than a 12-month extension. In the nature of things, that's his operative decision, and the operative decision necessarily involves that other options were not taken. 24 months, 36 months, or 48 months.
Mr. Rosenberg?
Yes.
From what you are telling us, that these were two extensions. Now, in anticipation of the consequences of the coming to an end by a fluxion of time,
Yes.
of at least the last extension, as
Yes.
you put it, what did the minister say should happen from henceforth? You can tell us. They're now taking it forward from there. Thank you.
Yes, the minister, and I certainly will take it forward from there, but can I just take one step backwards since we're talking about extensions? The minister grants an extension of 12 months. That extension is for a variety of purposes, and the purposes are self-evident purposes that can't really be quibbled about, because it is accepted that there have been 3 successive regimes, and ZEP is now coming to an end. In the nature of temporary permits which come to an end, particularly temporary permits which in substance or in fact have been of longer duration because of previous or earlier renewals, when they come to an end, there is dislocation, there are arrangements to be made. 12 months is granted on the basis that that is considered a reasonable extension in the circumstances. The minister said that within that 12-month, parties are advised to make the necessary applications for mainstream visas, to make the necessary applications for any exemptions, to make the necessary applications for any waivers, and equally to make representations. So this is in the context of a 4-year program where the permits have, to everybody's knowledge, been of temporary duration. And every single one of those permit holders would, not only should, would have been aware that on the 31st of December 2021, those permits were to expire. And it's not unreasonable to expect the beneficiaries of those rights to act accordingly, and if needs be, to take appropriate action timeously. In addition to that, and that just emphasizes the point, that throughout 2021, any reasonably prudent ZEP holder would have been aware of the need to assume some agency for their position, would have known what 31 December 2021 betokened. A year is granted in terms of which any permit holder is given an opportunity, specifically invited in letters that are directed to each and every permit holder virtually, in addition to publication in the media, are invited to make representations as to the length of that period, that extension. And that extension, we know, is one which was not cast in stone, even if at various stages announcements or indications are given that the minister is not minded to grant another 48-month extension at this stage, or at any stage. The extension is an extension which can be the subject of an application in terms of section 31(2)(b) for a further extension. It can be the subject of, it can be an extension which permits the party to apply for waivers or any other mainstream visa within that 12 months. It's not, as is demonstrated by what subsequently occurred, a situation that the minister has closed his mind to the possibility of further extensions. He's been advised by the Departmental Advisory Committee, and the position of the affected parties, particularly with regard to steps which are taken to make appropriate applications, are monitored, and within the 12-month period, a 6-month extension was granted. So, and with great respect, within this additional 6 months, there can be any number of applications, and doubtless there have been any number of applications, and we're not in a position at this stage to provide the numbers and the outcomes in this hearing on these papers, but there have been any number of applications, and there still will be applications for extensions, waivers, and for any mainstream permits or visas, particularly for extensions if the circumstances of an individual permit holder require it. So
the minister, in his mindedness that there will be an impact if and when the permits come to an end by a fluctuation of time, is considerate of listening to people to make submissions as to whether they will be able to uproot within the extensions that have been given. We're now at the last 6 months, is that correct?
yes.
And those consultations, should they have taken place before the extensions themselves, or upon, or after the extensions?
With respect, in this context, where one is dealing with a situation where parties' rights are, or the rights derived from the permits are due to come to an end. So the minister's not making a decision in terms of which he's taking away any rights. Those rights are determined by the permits. The permits are due to come to an end. The minister initially determines that it would be appropriate to confer rights in the form of an extension to cater for what he considers to be possible or even probable dislocation and challenges faced in the circumstances. He creates 12 months cognizant of the fact that permit holders would have been aware of the fact that the permits were to expire at the end of December 2021, but nonetheless 12 months is granted. Thereafter 6 months, a further 6 months is granted, and within that period there can be further ad hoc extensions if there are deserving cases. To answer your question, Justice Malindi, as to when it's appropriate to grant a hearing, in this particular case, it's appropriate to have regard to the fact that extensions are granted, and initially a 12-month extension, thereby conferring rights, thereby conferring an opportunity, a window to consult, and for any party who contends that the period is unreasonable, or any organization who contends that the extension is unreasonable, to make representations. This is an entirely distinguishable case, for example, from the ETV case that was referred to in yesterday and the day before, where parties' rights were due to be affected, parties' existing rights to receive television signals were due to be directly implicated. And a decision was made, as it were, to set a date to cut off the transmission, potentially cut off the transmission to many thousands of people. This is an entirely different situation. And here the extension is granted to afford time to consult.
Thank you very much. I'm sorry if I detracted you from your line of thought.
No, and if I may say so, may I just pause one? So in this context then, unlike the ETV cutoff date, at which people are going to effectively lose rights, a 12-month period is granted for people to actually exercise, to enjoy rights, and to consult and make representations. And in that sense, the 12-month period lacks elements of finality in that sense, and that it's a period that is not set in stone, and it's subject to extension where appropriate, and it's subject to blanket extension that has occurred, as we know. So in those circumstances, we submit that the primary challenge in relation to which so much attention was devoted as to procedural rationality and procedural fairness, if one accepts approaching this matter through the lens adopted both by HSF and the applicant in this present matter, and one accepts that what we're dealing with is a Section 31(2)(b) power that was exercised. I've indicated to you the only power that was exercised was the power that we've dealt with. And once one had recognized that that was a power in terms of which rights were essentially conferred for a particular purpose, it made no sense. In fact, it wasn't appropriate for consultation to take place at that stage. The extension was granted specifically to enable consultation to take place and representations to be made and considered. And that's why we submit that in the circumstances, the fair procedure and the rational procedure arguments are misconceived because they are tagged to a misconception and misdescription. And with respect, it's a clear-eyed misdescription of the decisions in question. The further challenges that were raised in this application, can I, just before leaving that point, can I refer you to the case of Mamabalo versus Rustenburg Regional Council? It's referred to in our heads, and in our submission, it properly captures a situation where consultation, necessary consultation, is appropriate after the decision, depending upon the nature of the decision. And we've dealt with that in some detail in our heads, particularly in the HSF application. The second challenge that is raised on the papers in this application, and I say the second challenge because the first challenge was the so-called ultra vires issue case, that in the exercise of section 31(2)(b) powers, there could be no termination of a permit without good cause. I've indicated why that argument is misconceived. The second challenge was procedural irrationality and unfairness. That's at 001-58 of case lines. I've dealt with that, and counsel for the applicant in this matter largely made common cause with the arguments put up on behalf of HSF yesterday. The third challenge is at 001-60 of case lines, paragraphs 165 and following. And that is a suggestion that the minister, in making the decision to extend as he did, failed to take into account adequately the decision that the Department of Home Affairs had capacity issues, and that secondly, he failed to consider the fact that the political and economic situation in Zimbabwe has not improved. Those are the two elements that go to the third challenge. The question of whether the political situation in Zimbabwe has or hasn't improved is absolutely a question for the minister to attach appropriate weight in his discretion in the context of a partial review. That is a weighting consideration. One is, you will have seen the competing reports on the papers as to unemployment rates, growth rates in the economy, contested allegations on the papers as to the current situation in Zimbabwe, whether it's improved or not. That was a question for the minister to weigh up amongst a range of considerations and attach appropriate weight to that. The minister quite clearly was of the view that in the context of this matter, the situation in Zimbabwe had, in his opinion, improved sufficiently as a factor, such as So it amounted to a factor that could be taken into account. And with great respect, an irrelevant, relevant consideration argument in the context of this kind, essentially, of polycentric decision is an argument that is going to be extremely hard to advance. With respect, one is not surprised that it wasn't pushed with any enthusiasm at all over the 2 days hearing that we've just had. And in a more energetic attempt was made today to suggest that the position in Zimbabwe had not improved, had in fact deteriorated. That's not an issue that can be resolved merely by a one-sided reading from certain of the extracts that of documents attached to the applicant's papers without recognizing the fact that this is a disputed issue, it's a value judgment, and it's a question for the minister to exercise his discretion. The third ground was the alleged consideration of irrelevant considerations. That hasn't been suggested. It's at 001-61. It hasn't been put forward in argument at all. It's plainly a make-weight. I'm not going to even refer to it. And the fourth ground was alleged material errors of law. The first one is difficult to comprehend. It said that the minister materially based his decision on the principle that after 31 December, holders of Zimbabwe exemption permits would be legally obliged to leave South Africa or face determinate deportation. That's an entirely logical and a fair factor to take into account, that all things being equal, but it doesn't detract from the fact that the minister would have recognized, of course, that asylum seekers amongst that cohort would have been and will be in a position to take advantage of our asylum management system. And of course, all that would require, by the way, is for the asylum seeker in question to report to a refugee reception center, and effectively, until their asylum application is finally determined, those parties will be permitted to...
Sorry, Applicant Rosenberg, I got cut off for a minute or so.
Sorry.
You are about...
I was dealing with the fourth ground of review, which was the material errors of law. In fact, it's the fifth ground, the material errors of law. It wasn't an error. It wasn't an argument that was presented.
Judge Collis seems to have frozen. I think she's moving on. She's not moving on the screen.
Yeah, they are back now.
All right. Thank you.
I think my...
I'm going to try and wind up now. I am appreciative of the time that I have been given by the court. The fourth ground, or the final ground, and the material errors of law, they weren't raised in argument before you. Certainly the first material error of law wasn't raised. The second alleged material error of law was that in making the assumed decision, the minister further assumed he was extending the permits that had been issued under the ZEP dispensation. It's quite right. He was assuming that, and he was intending to extend as he was permitted to do. The argument seems to have been that the permits had lapsed on 31 December, and it proceeds from a mistaken assumption that the minister's decision was taken on the or publicly communicated on the 7th of January. You know, the minister's decision was taken in September 2021. So, with great respect, as far as the prospects of success on appeal are concerned, it seems as or argued on behalf of the HSF and COMSA applicants that considerable weight is attached to the question of procedural fairness. I've made my submissions that is based upon a misconception of the decision. The second argument that has been advanced by all the parties is the question of whether the implications of the termination have been properly taken into account, and the submission, as you've heard, as I dealt with in the debate with Justice Melindi, is that the 12 months and the additional 6 months specifically is geared to take those considerations or consequences into account, and it's open to any party during that period to apply for an extension because of those consequences. So in our submission, accordingly, the prospects of success for the review, in fact, are not good if regard is properly had to the nature of the decision. If I may also then deal with another aspect.
Sorry, Mr. Rosenberg, I've just been requested that we adjourn for 10 minutes for a comfort break. Could we do that?
That's fine. Thank you, Justice Collis.
Thank you. Thank you, Paul. I
Thank
think
you, my lady. I confirm resumption of proceedings for 006386 of 2022. Thank you, my lady.
Thank you, Mr. Rosenberg.
Thank you, Judge Collis. The question of irreparable harm, in the first instance, it bears emphasizing that the 178,000 ZEP holders are effectively the litigants in the HSF matter, the CORMSA matter, and the litigants in this matter as well as in the what's the fourth matter? African amity matter. And in each of those matters, effectively the same litigants are advancing their interests. There's obviously a significant overlap between each of those matters. And if one compares the review grounds that are advanced in this present matter and the review grounds advanced in the HSF CORMSA matter, one sees the very, very considerable overlap, particularly the central grounds. And the point that was made when it was asserted that it was inappropriate to pursue interim relief is a point that was made many, many months ago when it was submitted that given the fact that this court would be determining the review and making final findings on that, it really made no sense for this applicant to seek interim relief. And the point that I made earlier today was that there appeared to be a belated recognition of this one court day before the HSF CORMSA matters started. That appreciation should have taken hold months and months ago, over 6 months ago. And it's in that context that it was said that interim relief was a poor choice for all the reasons we've indicated, and there had been time to alter course to arrive at a more logical court outcome, which had better regard to court resources and the effect of the decision of this court in the review. The approach that was adopted this morning was not an approach just to be obstructive and to gain time and just being difficult. The approach that was adopted this morning was, at the last moment, an attempt is made to do what should have been done months ago, and the prejudice that the minister faces by what with great respect is an eccentric device of trying to argue your Part B review relief on Part A papers is a stratagem that should never have been resorted to. That's why we opposed it. So there's nothing malevolent about it at all in the position that the minister adopted. Now, as far as the apprehension of harm is concerned, counsel for the applicant's rhetoric took flight when we were told that what would happen on the termination of from the 1st of July would make some of the horrific historical scenes of forced evacuation and flight from Uganda pale into insignificance. With great respect, it's not an appropriate analogy at all. We know that with regard to the 178,000 parties in question, many of them will have been in a position to make application to address their position. Those of them who haven't may still do so. Those of them, for example, who are desirous of participating or applying for asylum will present themselves at a refugee reception center. We know, and our case law has eloquently and effectively established their rights in this regard. We know that they will be entitled to an asylum seeker permit, and it may be that if the asylum management system is under pressure, it may take time. And one can just speculate, it may take time for that process to be managed. But there's no question that any asylum seeker who presents himself or herself to a refugee reception center will be entitled on presentation to an asylum seeker permit, will be entitled to remain in the country until such time as the question of their status has been determined. Equally, any illegal foreigner, or that would include a permit holder on or after 1 July, who's an illegal foreigner in terms of Section 32 of the Immigration Act, as we've emphasized in our papers, is in a position to apply for authorization from the Director General to remain for a limited period, shorter or a longer period. And in those circumstances, as we've indicated in our paper, that procedure is dealt with in terms of Immigration Regulation 30, which provides for effectively parties who make that application to be issued with what is referred to in the papers as Form 20, which gives them an opportunity to remain pending the determination of whether, in fact, the Director General grants authorization to remain pending whatever status determination is made. And finally, of course, in any event, deportation in terms of Section 34 is a procedure that requires the exercise of the discretion, can be resisted on appropriate grounds, and doesn't follow as without more as a mere formality. So the suggestion that on 1 July 2023, this apocalyptic kind of situation that has been sketched will take place is, as everybody knows, not an accurate or fair representation of what will happen. So the position is then that these litigants have 2 cases before this court would have been argued for review relief, 2 cases in which they have requested the court in respectful but forceful terms to do what can be done to provide them with a judgment one way or the other before the 1st of July. And in those circumstances, we submit that with great respect, there is no apprehension or reasonable apprehension of irreparable harm. If the judgment should be granted in these parties' favor, and if, for example, the minister were minded to take that judgment on appeal, in terms of the order that has been presented to this court, provision is made for appropriate remedial action in terms of Section 172(1)(b), that's dealt with elsewhere. But whatever that protective remedial relief is, in the event of an appeal, these litigants would be able, if appropriate, to seek the protection of this court for the immediate implementation of remedial relief, which was designed to protect them if that becomes necessary in terms of Section 18(3). So with great respect, the picture that has been sketched of the irreparable harm that will in all likelihood ensue after 1 July 2023 is unhelpfully presented and exaggerated. The question then of the balance of convenience similarly flows from that. If interim relief is not granted and the applicants are successful in the main application, it's hard to conceive that they will suffer any inconvenience. And by that, I refer to the main application in terms of the HSF and COMSA applications, in which these applicants are effectively the applicants. And as far as an alternative remedy is concerned, we've made our submission on that score. That's become abundantly clear it's become quite clear from the way this matter has panned out today, why in fact interim interdictory relief was not a sensible or prudent remedy to pursue in the circumstances. Aside from the alternative remedy of the review that has been argued, of course, ZEP holders have a number of permits and visas and authorizations for which they can conceivably apply in terms of the Immigration Act. So we say that in those circumstances, interim relief is not warranted, it's not appropriate. If this court is minded to grant interim relief, and this is tied back to the submissions we made in relation to alternative remedies, any such interim relief should be in fact tagged to the outcome of the HSF and COMSA applications. There can be little doubt that this Part B review application, which has not been advanced one iota since the time the matter was launched, will never see the light of day. This matter, this issue is going to be determined by the applications which were heard by this court over the previous 2 days, and possibly by the African Amity application, which is due to be heard tomorrow. Part B, with great respect, will be stillborn. And the appropriate course is, if an interim interdict is to be granted, it should be granted pending the determination of the HSF application, HSF COMSA application, pending the judgment of this court, and depending upon the outcome of this court's judgment in that matter, if further protection is required pursuant to that, then in fact the necessary applications could be made, whether in terms of 18.3 or otherwise, for appropriate relief at that stage. So at this stage, if interim relief is to be granted, it should be pending the outcome of the HSF and COMSA applications. As far as costs are concerned, there's absolutely no reason why the normal rule shouldn't follow. An interim interdict, a successful party in an interim interdict almost invariably has to be satisfied with costs standing over until the determination of the main relief to see whether in fact there was any entitlement to costs depending on ultimate success. There's no reason why that well-established practice should not be followed. So those are our submissions on the court. Unless the court wishes to hear us on any other aspect, we've got nothing further to add. Thank you, judges.
Thank you, Mr. Rosenberg. Judge Malinde, any questions?
Thank you, my sister. No questions.
Judge Mota?
Yes, thank you. No questions.
Okay. Thank you, Mr. Rosenberg. Thank you, Mr. Kaitobi. Are you ready for your reply? You're only going to have 30 minutes for that.
Who's muted? You. I'm muted. Sound is off.
No, you're on.
Sound is not off.
No, we can hear you. You may proceed, and you only have 30 minutes.
Justice Collins, I can't actually hear you. I wonder whether the problem is on my side.
I don't know. Can anybody else hear me?
I can hear you, Judge.
Okay.
Yes.
No, I
we hear
think
you, Justice
that was
Collins.
on my end. My Leonard Jr. who's more technologically advanced, has assisted me.
Okay. We proceed then. You have 30 minutes we've allocated to you for the reply.
Thank you, my lady. Let me start with where Mr. Rosenberg ended, which is probably the most important part of the case, which is we seek an interim interdict in order to protect the rights and interests of the applicants post the 1st of July. And what is the rebuttal to that? My understanding of the rebuttal is some of my clients would have made application for what is called regularizing their position, seeking extensions, seeking waivers. Mr. Rosenberg says they don't know how many applications have been made, how many applications have been approved, and what the status of those applications that have not approved actually is. The papers say approximately 6,000 applications have been submitted or representations have been submitted. But the papers don't say what the status of each is, nor do they give any indication that they would be approved. So the first suggestion that has been made that my clients can make applications is cold comfort. It is unsatisfactory. It does not meet the requirement for an interim interdict not to be granted. That's in relation to people who have made applications where the number ranges between 6,000 to 8,000, but where there is absolutely no information emanating from the department about the status of those applications. But in any event, 8,000 out of 178,000 is a drop in the ocean. So the human catastrophe is not resolved by suggestion 1. Suggestion 2 is those who have not yet made applications can still do so. But this is defeated entirely by the stance taken by Mr. Rosenberg's client. At page 003/24, this is how the department puts the position at paragraph 76 and 77. At paragraph 76, they say, if the parents of the children in question are genuine asylum seekers, they are entitled to apply for asylum and will not be separated from their children. If children are studying in South Africa, there is nothing to preclude them from seeking to regularize their status on this basis. Then in paragraph 77, which is really the nub of the problem, those ZEP holders who have chosen not to take advantage of the regime that allows them to regularize their status will likely become undocumented on 30 June 2023. However, if they have a basis on which to seek an extension of their ZEPs or those of their children, it is incumbent on them to make representations to the minister. In those circumstances, there is no breach of their children's Section 28 rights. So what are they saying here? What they are saying, they're making it abundantly clear to the court that come the 1st of July, you are to be treated as an undocumented migrant. You are going to be an illegal immigrant in South Africa. What are the consequences of being an illegal immigrant? Mr. Rosenberg has not addressed the court on the two that I proposed, which are natural consequences of the act. One, you are liable to be deported. In fact, Section 32 says you shall be deported. 2, you are also liable to be sanctioned criminally. You may be charged for violating the Immigration Act. So what we have, which has simply not been addressed, is we have literally tens of thousands of people that overnight will be turned into illegal immigrants. They will also be turned potentially into criminals. And hence I say many people will self-deport. And we still cannot work out how the government is hoping to deport by enforcement of the law tens of thousands of people. The reason we have to stress this point is because it is easy. It could have been easy for the government to concede the application entirely and to say on oath, we concede that come the 1st of July, pending the outcome of this application, no one will be deported, no one will be arrested. In fact, everyone who is under the ZEP program shall be treated for all intents and purposes as if they still continue to enjoy the rights that they have under the ZEP program. And that is not necessarily respect to us alone. It is also respect to the judicial process. Because the reason we are here is so that if it turns out that Part B is good, we should not be in a situation where the harm that we are trying to prevent would have occurred in any event. The problem with the suggestions that have been made, either to make applications or those who have not yet done so to do so, is also undermined by another reason. I showed the court the statement from the department's Director General, who says, our office has no money, it has no people, it has been overwhelmed by all of these applications for different types of visas. Now, it's completely unrealistic to make the suggestion that my clients are now expected to go to the same department, apply to regularize their status so that they are prevented from becoming illegal immigrants on the 1st of July. What is the other suggestion of Mr. Rosenberg on behalf of his client? I'm not personalizing the debate. He says that those who want to apply for asylum status must go to the refugee center. So what will happen, in effect, if you accept that you are tens of thousands of people into refugees, which is in itself a conflict of why the scheme was introduced. The scheme was introduced precisely because the refugee system is dysfunctional. The facts on this case show that the refugee system is still dysfunctional. And that dysfunctionality has been exacerbated by the reduction of the budget. So again, the suggestion that they should go to the refugee centers, they should apply for asylum seeker status. And if they do apply for asylum seeker status, they will not be deported because there is a period there where they can stay for 40 days. And what we know here for sure is this was not a problem of asylum seeker status. This was a problem of a combination of political instability and economic migration. This is what the South African government recognized, which lies behind the ZAP program. It turns out that there is also a deterioration in the political and legal situation in Zimbabwe, such that some people would qualify as asylum seekers too. But we know that the heart of the problem was economic migration. That's what the ZAP program was designed for. So to say that economic migrants must somehow turn themselves into refugees simply makes no sense at all. Then the department has a fourth solution to the problem of what will happen after the 1st of July. It says that we must rely on the application brought by the Helen Suzman Foundation. But there are two foundational problems there. There is no basis to argue that we are applicants in the HSF application. We are not. The HSF is not acting on our behalf. We are acting on our behalf. There is no basis to say that we are now instructing the HSF to bring this application on our behalf. We have our own identity, our own reasons, and our own legal arguments that some of them overlap, others do not overlap. And it would be a very odd judgment in which a party comes to court seeking interim relief. They are told that there's someone else in a different application who sought final relief, and I cannot give you interim relief, even though you meet the requirements for interim relief because of that other party. It would be an unheard of application. So the first problem is that's not our application, that's the HSF application. And it would be odd if this court threw out our application and told us to rely on the HSF. But there is also a substantive problem. The HSF application is an application for final relief. My clients were deliberate in their choice of litigation to bring an application for interim relief. What had happened was that there was a protest from the department about the propriety of the interim relief. We genuinely thought that they would welcome the conversion of the interim to a final application. We were just taken aback this morning when they resisted that very suggestion, because their papers, as I showed this morning, are replete with the suggestion that the best outcome for us is to join the HSF application for final relief. We were just taken aback when they resisted that. In fact, even on Tuesday, when the suggestion was initially mooted, no one could have imagined that when we tried to do precisely what they claim in the answering affidavit, that would be opposed. Now, if it is successful, the HSF application, this is what will happen. The department may appeal. It is entitled to appeal, and that's not a criticism. And an appeal in a final interdict automatically suspends the application unless a court exercises the discretion under Section 18, which means that we remain vulnerable to deportation, we remain vulnerable to breaking the law, and we remain vulnerable to prosecution. Things that could have been avoided by a mere administrative decision by the department, but it has refused to come on oath, make the undertaking that we will not treat your clients as illegal immigrants. It says you have to infer from many facts that in the past we have not treated people as illegal immigrants. The question I asked when I closed my argument is, why are they refusing to make an explicit undertaking under oath before 3 judges that no one in fact will be treated as an illegal immigrant by virtue of the lapse of the ZTP? Why? If they are genuine about the suggestions and intimations that they have made in their answering affidavit, why don't they just make a simple suggestion to the judges so that we all dispense with the need for Part A? It seems that it would be risky to leave these applicants in a vulnerable position. It would then turn the application that they have for Part B into an illusory application that serves no purpose. On this topic, a final point that is made by the department is that if interim relief is to be granted, it should be tied to the HSF and COMSA application. In other words, you should say in your order, pending the determination of the HSF application, the following interim relief is granted, which is in paragraph 1.1 to 1.3 of the notice of motion. We leave that in your hands, but we do suggest that, again, to bring that application into this application would be unprecedented. The correct and competent order is that it is pending Part B. I am not as pessimistic as Mr. Rosenberg about what will happen to Part B. It's unclear to me that Part B would be rendered moot by the success of the HSF or COMSA. It seems that Part B of this application remains alive, regardless of what is the status of the HSF application, which we have not joined. We are not an interested party. We are not an intervening party. We have separate self-standing application. And that separate self-standing application has in fact been recognized by this court in the way in which these applications have been dealt. So it seems that if you are with us, the correct order is that you should grant our interim interdict, and that interim interdict must be subject to the success of our Part B. If my clients wish to join the HSF application on appeal or at any stage, they will make that application. But what is inappropriate is that they should be compelled by a judicial determination that they should be parties in an application that they've elected that they will not be parties to. They have their own reasons, but even the factual and legal basis for the arguments are different. Then there is a suggestion that we should be denied costs in the interim interdict, and they should stand over for determination in the final interdict. you will obviously see the contradiction where it is suggested that the final interdict will never be had. But it is also suggested that costs must stand over, pending what, in an application that can never be had. So we go back to where we started. The department tried to postpone this case this morning. It is now trying to postpone a determination of costs because this is an application that could have avoided by making an appropriate tender openly on record, which we would have accepted if it satisfied the requirements in paragraph 1.1 to 1.3. It refused to do that. And it is not fair for my clients, even on BioWatch, on any principle of cost, that you have vulnerable people bringing litigation against a state entity, being denied their costs and told to wait in circumstances where the very reason that they were entitled to the ZEP was because of their vulnerability. So we would suggest with the greatest of respect that if you are with us on Part A, there is no reason to burden the court that will be hearing Part B with the cost of Part A. The costs of Part A in any event are separate, self-contained. Once you have made a determination, you should grant those costs. And you've got to take into account that ordinarily, in any event, sorry, my lady. Yes, and in any event, you know the principle that the unsuccessful party pays the costs, and you also know the principle in cases such as this, where constitutional issues are at stake, flowing from the old decision of BioWatch, that even if we lost, we wouldn't pay the cost. The government would pay the cost. So everything points to one direction, that a success by my clients should be accompanied by a cost order. Let me then spend 5 minutes on the what I would call the merits of this case, but there hasn't been a significant challenge to the premises of our case. The first one harks back to the issue about a non-decision. And it's a very odd argument because what it now tries to do is to separate the minister from his DG and say we must look at what the minister says, ignore what the DG says. But what I did at the commencement of my address, I cited 4 sources for the argument that both the minister and his DG, they took a decision. The minister in paragraph 11 rather, of the statement of the 7th of July makes it abundantly clear, I took a decision. The Director General in the 2 letters and in the affidavit in the 2 paragraphs makes it explicit that his boss, the minister, took a decision. But both the minister and the DG make it clear what the nature of the decision was. They say that decision was not to extend. And that is not surprising because, as Mr. Rosenberg correctly concedes, once the minister and the DG knew that the ZEP was lapsing at the end of December 2021, they had a range of options. One of them was to extend the ZEP, another was to terminate the ZEP, the other was not to extend the ZEP. So the fact that we say it is a decision is precisely because of the existence of a range of considerations that go into the exercise of a discretion. So you chose one option out of 3. That act of choosing option 1, not option 2 and not option 3 is what in administrative law is called a decision. It is the application of mind to a range of factual circumstances to come to a final conclusion. It is not a scenario like in penalty, where the act says, if you are absent from work from 30 days, you are deemed by operation of law to have been terminated. It is a scenario where there is nothing to be deemed. And what happens is dependent on your own judgment. So it's that judgment that the minister exercised that we say constitutes a decision. And if you look at the definition of a decision in Paja, it's bang on point. It's precisely what a decision is. But again, we don't have to speculate here because we've got 5 sources that I pointed to. And even though Mr. Rosenberg tried to say there's confusion, there is no confusion on the facts. Secondly, we also don't have to speculate about what the legal basis for that decision was. It's a decision not to extend based on section 31, subsection 2, subsection B of the Immigration Act. And that is why it is an impossible argument to resist the ultra-virus point. Because once they cited that section, it was incumbent upon them to show that as a matter of law, they acted within that section. They failed to do so in two respects. Section 31(2)(b) does not authorize the decision not to extend. It only contemplates a withdrawal, and this was not a withdrawal, and therefore it is outside the provisions of that act. Even where it were to be construed as a withdrawal, it is still ultra-virus because it does not satisfy the requirement of good cause that has been made. So it seems that the argument on ultra-virus is unassailable. The only way that one gets around it is through adopting this utterly untenable suggestion that somehow there was no decision and somehow we must ignore what the minister said and somehow we must distinguish what the DG said on behalf of the minister. The fact of the matter is you have to work on the facts, and on the facts there was a decision, and on the facts that decision was under section 31(2)(b). That takes me to another total misconception that has been raised, which is what reasons underpin the decision, and that goes into the arbitrariness. What reasons underpin the decisions? What would have struck my lady and your lordships? What would have struck you is the total failure in oral argument to engage with the actual reasons. There are 4 reasons given. 4 reasons given. They are all unrelated to the justification for the introduction of the ZEP program in the first place. The minister never said in those decisions that he has applied his mind to the political, economic, and human rights situation in Zimbabwe. And on the basis of the following facts, he was satisfied that the prerequisite for the introduction of the ZEP no longer exists. That is not, as Mr. Rosenberg suggested, to invite the court into a political arena. It is simply to ask of the minister whether he has acted rationally or not. He said, I'm introducing the ZEP because it's pending an improvement. Those are his words. It's pending an improvement to the political, economic, and human rights situation in Zimbabwe. He just never produced any facts that at the time he took the decision, he applied himself to that consideration. The 4 reasons that he gave do not engage with that topic at all. When you look objectively at the 3 reports, there are no conflicting reports, as Mr. Rosenberg suggested. There are no competing or conflicting reports. There are 3 reports given by us, 2 reports given by them. They all say the same thing. They say ultimately there is a marginal improvement from 43% to 41%, but they say the unemployment is still high, the poverty levels are still unacceptably high, the inflation, I think last year was 67%. They say economic migration is still a problem. They say the human rights situation in Zimbabwe has deteriorated. In fact, things have become worse in relation to the repressive regime of Emmerson Mnangagwa, and all of the promises that were made when he became the president have in fact deteriorated. So there is no conflicting or competing reports. The reports say the same thing. So once we are there, we are now absolutely clear that there is no basis on which this decision was taken. And my learned friend points out that the judgment of Minister of Defense versus Mutau, in fact, defines the concept of good cause at paragraph 54. And it says that good cause may be defined as a substantial or legally sufficient reason for a choice made or action taken. Assessing whether there is good cause for a decision is a factual determination depending upon the particular circumstances of the case at hand. But what is crucial here is that it's not up to the minister to tell the court what is good cause. The minister's job is to tell the court what he at the time considered. But whether there's good cause or not, as required by the statute, is a legal determination based on objective facts. You cannot have a scenario in which the minister tells you that there is no violence in Zimbabwe when all of the evidence in front of the court says there's violence in Zimbabwe. And that's the crucial distinction between a statute that says if in the opinion of the minister there is good cause, and the statute that says if there is good cause. One calls for a value judgment to be applied by a court, the other calls for a measure of deference. The statute here says if there is good cause. It doesn't say if in the opinion of the minister there is good cause. So We asked at the beginning that final relief should be granted here because there is plainly no defense. But we accept that the decision has been taken that only interim relief will be entertained. The case for interim relief is an overwhelming case. The attempt at providing a defense has utterly failed. We should be entitled to the order sought in Part A, together with an order of costs. Yes, thank you, my lady. I have nothing further to add.
Thank you. Judge Malindi, any questions?
Thank you. Just one question, my sister. Mr. Mugwaitobi, Mr. Rosenberg, in reference to paragraph B, Roman figure 2, seems to say good cause should be shown if there's a withdrawal. And in fact, the 12 months up to December 2022 was a conferral of right in the same terms as the previous regime. And again, the 6-month extension itself was a conferral of rights of permanent residence, not a withdrawal. Could you assist me in that regard as to whether he is correct or incorrect?
No, he is incorrect. Let me explain. His client says, I have acted under section 31(2)(b in doing what? In not extending. Question number 1 is, does section 31(2)(b grant the minister the right not to extend? The answer to that question is obvious. It doesn't. Now, he acted outside of the provisions that he purported to be relying upon. And that is why the case of Harris and the case of Langa versus Premier Limpopo is on point. If a minister cites statute X and it turns out that his action is inconsistent with the statute that he has chosen, the minister has acted unconstitutionally and unlawfully in breach of the provision that he purported to be acting under. So here we have a scenario in which the minister does one, purporting to rely on a statute, and then it turns out that that statute doesn't give them the rights that they said, in other words, the entitlement not to extend. Now, if a minister had said, I am withdrawing the rights, the question would still arise whether or not the action of withdrawal is being informed by good cause, and whether or not the action of withdrawal has taken place when special circumstances exist. And admittedly, both of those would then require an assessment by the court of the merits underpinning the decision. So he fails on ultravirus for 2 reasons. One is he has no authority under the act, under the statute that he cites, except by withdrawing. And if he purports to be withdrawing, he has to show good cause and he has to show special circumstances. And that's the decision to terminate. What he cannot run away from, Justice Malindi, with respect, he cannot run away from the fact that what he calls the operative decision. The operative decision is clear. It's taken in September 2021. I am not extending the scheme. And you've got to understand the scheme as precisely what it is. This is a scheme that has operated for 14 years. And at every stage, the scheme has been extended by anything between 3 years to 4 years. The truth is that the scheme has ended. There will be no extensions. There will be no new scheme. What will happen is that on an individual basis, there will be adjustments to time. But the scheme of the ZEP comes to an end. Now, that is the point that we say he overlooks. He overlooks the fact that the operative decision of the minister was the termination of the scheme. He says so himself. He says, I've decided not to extend the ZEP program. So the ZEP program has come to an end. What is now happening is introducing other things in place of the ZEP program. But those things that he is introducing are actually poor substitutes for the substantive benefits that my clients enjoyed under the ZEP program. For instance, one of them is substitute is, oh, well, stay for another 12 months. Another one, which is the substitute of the ZEP program, oh, well, stay for another 6 months. But those are all substitutes of the ZEP program, which he has explicitly stated as terminated. There will never be a ZEP program until the court says, well, it should continue under the following circumstances.
Thank you, my sister.
Thank you. Judge Mota?
Yes, just one question. Your part B, I'm not saying you're going to be successful, but if you were to be successful, how soon should it be expected to be launched?
Well, it has been launched. What has not happened is it has not been supplemented. I don't know whether a record has been provided for Part B because it's awaiting. Well, no record has been provided. So, but I think we have to compare the production of the record. But as soon as the record has been provided, we have to move with speed to getting it set down because we might lose out on the appeal, that on any appeal rather, that the HSF application may generate.
All right, no further question.
All right. Thank you. I think that brings us now to the end of the proceedings. You took more of the time that you had indicated to the court. You were going to take in your joint practice note, but we appreciate the fact that some time was taken with the earlier points raised when we commenced the proceedings. Thank you for your arguments. The court is going to reserve its judgment.
Thank you, Justice Collins and the members of the.
Thank you. You're excused then.